Well, pardon to make a mention. Yeah. Your Lordship, bank has issued notice to delivery of possession of the secured assets. There is one-time settlement out of 40 lakhs.
Lord, there is a matter where the interim order is passed in, and after the March, Lord, March 24, matter is not listed. Bank is not in a position to move, Lord.
Yes, Mr. Pali.
My lord, sir. Item number 97 and today's list. I was praying that, my lord, any day if your lordships are convenient, this was being mentioned in the last week also, your lordship had given me liberty to make a mention. So any day your lordship wants it.
The other side is ready.
My learned senior friend, Mr. Lenka, is there. Any day in the supplementary list if your lordship wants. Any day.
Okay. So,
excepting sixth term, nahi.
How much time it will take according to you?
It will take some time. Sometime.
Let it come then next week on Tuesday to Wednesday. What is that item document? So let it come on 10th.
9th.
9th is a supplementary upon any 11th.
Grateful.
The petition is in the order of the matter. This letter again coming to
Please give it.
Pardon to make a mention, my lord. The weekly list item number 136, my lord. Today I'm filing the rejoinder affidavit. Weekly list.
Have a copy on the other all
Yes,
other
my
side.
lord. Petition already received.
137.
136, my lord.
36.
Yes.
One counsel for the petitioner files the rejoinder affidavit which is taken on record. Let a copy of the same be served on all other parties. Put of this matter next week. Yes.
Pardon to make a mention, my lord. I mean virtual. Weekly list item 72, my lord. Am I audible to your lordship?
Yes.
Weekly list item 72.
22.
72, my lord. It is the removal of defect, my lord. After restoration of the writ petition, my name has not appeared. It's a transport bib. My name may be reflected and matter will be taken up week after, so that I will remove the defect in the meantime.
Just a minute. 72, there are so many defects pointed out by the stamp reporter.
My lord, I have to remove those defects within a week. Within a week.
Manmoy Kumar Das.
My lord.
Counsel will submit that he has filed Wakalatnama after taking no objection from the earlier MK's counsel.
It's a CMAPL has been allowed. After the matter is dismissed, I filed a CMAPL. It was restored. Now my name has to be reflected.
Right, that is what is his name has not been reflected in the policy. Let the name of God to be reflected in the policy. And counsel have removed defects as pointed out by the stamp reporter within a week. Matter that thereafter. Yes.
Any date, let's say a fixed date, madam.
The moment you remove all the defects, it will be listed. That is the order passed today.
I'm obliged. Okay. I'm obliged.
M.K. Das.
I mean, I don't know 82. That my Mr. Air Das took time while counter. He has not filed. And just now I asked him, he said that during this course of this week he will file. And taken up next week. Or a 1 o'clock.
82.
My lord. This is endowment matter. Right, and on all special assignment, just come to this.
So let him come and say this thing so that we can be.
I mean, it may not reach.
No, it's all right. But you said that he intends to file.
Last because he took time to file counter.
So when the matter reaches, we can take up. Otherwise, if he comes and say that it may be adjourned to next week, so that in the
Supplementary list, item number 1 for judgment, Jesse 9 of 2024.
The primary ground of assailing the impugned judgment in the appeal is that the trial court failed to properly consider the appellant's plea of insanity. Whereas, the learned trial court, while dealing with the matter in trial, held that the medical evidence presented, including the appellant's treatment for conversion disorder and psychosis after the incident, does not sufficiently establish that the appellant was legally insane at the time of the offense. It is in this backdrop, upon a thorough examination of the evidence on the record, this court concurs with the finding of the trial court as well as its finding in rejecting the appellant's plea of insanity. Conversely, the evidence on record clearly establishes that the appellant committed the murders with full knowledge of the nature and consequences of his action. The subsequent mental health issues observed during his incarceration do not absolve him of his responsibility for the heinous crime. Since the sentence awarded is absolutely in accordance with law, there is nothing to interfere therewith. The JCRL is dismissed. Before parting with this case, we place on record our appreciation to the learned amicus curiae and the learned additional standing counsel for the assistance rendered by them in disposing this appeal.
I agree.
No pledge.
Blood 22/8, your lordship had and concluded this matter. On that day, the learned counsel presenting 4, 5, and 6 opposite parties, that private opposite party was not present. Therefore, your lordship directed me to inform them. And my friend is appearing for them. And
And
he,
opposite party
4, 5, and
4,
6.
5, and 6. No, it enters a seniority and it from since 2015 and now it is 2024. Now it is a supplementary it will be
But that I am challenging from,
answered.
that I am challenging from 2016 itself. That when this seniority list was published, that 2 issues, your lordship kindly recollect, my lord. 3 issues were framed by the law and
No,
tribunal.
you said that the hearing is closed, but he has not been
No.
given the opportunity. So
That-
since he was
that's
not
why you are-
present on that day.
Yes, yes, my lord.
So you said that hearing is closed. So
Yes, but because of he was not present.
right, so obviously opportunity has to be granted
Yes.
in order.
I will also file an affidavit to the regender clarifying some facts.
What is the status now about this? Because the seniority was determined way back in 2015 or 16.
As per the order of this order of the learned Central Appeal Tribunal, man, its seniority has been fixed recruitment year 2009-10.
No, that is under challenge. What is the presence of whether any further promotion has been made or have you taken instruction or
No promotion has been made as yet, my lord. That in 2015 they have given 9-10 seniority, year of allotment 9-10, and intersa seniority that your lordship kindly recollect.
Yes, what my lord wants to know from you is a clarification with respect to the position, because as apparently it shows from the order of the tribunal your prayer has been allowed in a way. You do not challenge the 2009-10 recruitment. Your only grievance is that reshuffling of the name in the list. The person who is having mark pre-revised salary is to be given the primacy than the person subsequent to that. That is the only grievance. What my learned senior wants to know, in between, several things must have been passed on. Several promotions must have been taken place. So what is the status?
Let me to clarify that. Initially, they have given me 2008 and 9 senior.
That we understand. That we know. It is no more. It is no more.
Recently.
We are not disputing now. We are at time then.
9, 10, they have granted, I have accepted.
So many promotions have taken place in the meanwhile.
Don't make a submission without taking instruction. 9 years is not a small gap.
This issue has not been.
Yes, what do you say?
15 first time, they have issued the seniority list where these 3 private opposite parties were shown senior to me. But all the persons were given by recruitment year 2009 and 10. But subsequent, I challenge that they will be below me. That when that issue was pending, then they again revised my seniority from 2009-10 to 2010-11. Then all the issues again were brought to the notice of the Learned Tribunal, and Learned Tribunal decided the issue so far as 2009-10 is concerned.
So we are still in the same position, in the same post as on date.
Yes, my lord. Yes, and 2016, I am challenging this thing. I am challenging 2016.
That is why my lord is saying that whether the status of the person
still, my lord.
No, let it.
Same, or you have to take instruction for that.
No. They are now above me, my lord. They are now these 3.
And this is the last promotion. There is no further.
ITO promotion.
There is no further promotion.
No. Income tax officer promotion was given, and still we are not in that grade.
Yes, Mr. Rajguru.
They are in the same grade. ITO. But I have to take instruction regarding the present position.
Yes, that is what I say. You take
can be taken up next week. There is
take
whatever you want to file also you can.
Yes.
What you want to file?
One thing with regard to the panel.
No. What you want to file? Any further affidavit or anything? Just a minute. Affidavit on behalf of the OP number 1 to 3.
Reply to the rejoinder.
In reply to the rejoinder.
Okay. And present status of the parties. Okay.
Yes.
Okay.
In this regard, I will take instruction.
All right.
Exactly.
The are Mr. S.K.Sahoo, Learned Counsel for the petitioner, Mr. Vani Shankar Raiguru, Learned Central Government Counsel for opposite party number 1 to 3, and Mr. D.K. Mahanti, Learned Counsel appearing for opposite party number
4 to 6.
4 to 6. During course of argument, the Learned Counsel, Central Government Counsel, submits that he intends to file an affidavit, reply to the rejoinder filed by the Learned Counsel for the petitioner, and also to obtain instructions regarding the present status of the respective parties, and the matter may be taken up next week. This
on 10th years.
Okay, Christian. Is this matter on consensus, on consensus of all the parties? Is this matter on 10th September 2020?
Rejoinder filed way back, but they have not filed.
The copy of the affidavit we served on the Learned Counsel for the petitioner, served on the Learned Counsel for opposite party number 4 to 6 in advance, right?
Yes.
Item 3.
Oh, sorry, Lordship. It is negative.
Yes.
Lordship, just I prepared a small dead chart. Only to apply for Lordship the sequence of events in this matter, Lordship. How Lordship the bank during pendency of the writ application and also by virtue of an entry murder.
Mr. Dowdy, your prayer is to challenge the e-auction sale notice
Lordship.
Of the year 2021.
Lordship.
And that is Annexure 8.
Lordship.
So, what has happened in the meantime?
In fact, Lordship, my dead set, that will say the entire events during operation of entry murder.
Yes.
Lordship, they have sold out the entire property and they have created.
It is
Already sold.
Already sold.
Oh, it is sold to whom?
Lordship, my friend is appearing, Lordship. I have made also named party. Lordship.
Let us say the interim order was passed
Lordship.
On 16/5/2022.
Lordship.
And that was, of course, it was not passed in presence of the opposite parties, but notice was issued.
Notice issued.
So, when it was sold?
Lordship, kindly come to my dead set, Lordship. That is page 5, 17, 12, 21.
No, before the interim order.
No, Lordship. After the interim order, Lordship.
16/5/22.
Let us be clear. 16/5/2022 ରେ interim order ହେଲା.
Lordship.
So, ये sale ଟା କେବେ ହେଇଛି?
Sale ଟା ହେଇଛି 17/12 ରେ, Lordship.
17/12/21 ରେ.
21.
ଆଉ ତାହେଲେ
interim order, Lordship. Kindly say interim order, that is on.
And interim order is 16/5. That is the very fast order.
Lordship.
Sorry.
Lordship.
So you should have brought to the notice of the court that such a thing has happened.
That has been brought to Lordship notice, Lordship, and that is contempt petition also pending before Lordship. And in contempt, your Lordship directed to deposit the entire amount, and that amount has already been deposited before the bank, Lordship.
Your very first submission is that in spite of the interim order, they sold it to Mr. X.
Lordship.
But we find that the interim order was passed on 16/5/2022.
That is previous writ application, Lordship, not in this writ application, Lordship.
এই অর্ডারে এই রিট পিটিশনটা প্রথম অর্ডার হচ্ছে 16/5/22
Lordship.
number 1.
No, Lordship, kindly see my dead chart. It will be very clear, Lordship. Dead chart I can.
Dead chart আমি বুঝি এই জিনিসটা আমরা ক্লারিফাই করুন আগে.
Lordship.
16/5/2022 ରେ ଆପଣ ପ୍ରଥମ ଥର ପାଇଁ interim order pass ହେଲା ହଁ ନାଇଁ କହୁନାହାନ୍ତି?
No, Lordship. In fact, Lordship, in this case, it is subsequent, Lordship. This writ application.
লেখা ହେଇଛି clearly lease this matter so and so, and till next date the execution of the sale deed shall be kept in abeyance. That is the order number 16/5/22.
This writ application, Lordship, after completion of the sale deed. This writ application after completion of the sale deed. Because prior to that, there is another writ application. In the application, Lordship granted me interim order and direct to deposit some amount to subject to not to take any coercive action. I deposit the same said amount, Lordship, and despite deposit said amount and knowing fully well there is a writ application pending before Honorable High Court of the operation of interim order.
Execution of sale deed shall be kept in abeyance କରାଉଛି. Sale deed ର ମନେକର that has already been acted upon. Possession has been handed over.
Lordship. It is, Lordship, and at the same time, contempt Lordship direct to deposit the entire amount. Lordship, kindly, please, Lordship, come to the death chat. Otherwise, Lord, I can convince you, Lordship, because there are, Lordship, different writ application filed. In first writ application, Lordship directed because it is subsequent writ application by making the party the subsequent auction purchaser. So prior remote, but he also subsequently came to
the writ petition which was filed in WPC 26724 of 21.
Lordship, 21.
There the interim order was passed not to take coercive
action, Lordship.
But by then 13/4 notice was already there.
That is there. Yes. That was there, Lordship. That was there. But
why is contempt then?
Subject to payment of such amount.
That amount is a paltry amount that you have been asked to deposit. That is 8,50,000 rupees.
Lordship.
Your loan amount was 30 lakhs.
Yes, Lordship.
you did not like to pay anything, and you even did not pay the interest.
Lordship.
Now a paltry amount of 8,50,000 has been paid. Prior to that, probably you have paid 5 lakh rupees.
Lordship.
So 5 lakh and 8,50,000 rupees you have paid so far.
Lordship.
Out of the loan that you have taken in 2017,
Yes,
30 lakhs.
Lordship.
So what about the interest you have been telling by filing representation after representation, asking the bank to consider your case to wipe out the interest and to go for one-time settlement.
Lordship.
Several petitions you have filed, bank rejected. And thereafter you have come. So by then, almost all things have happened.
Lordship, I place the debt at Lordship. Then I can start.
What will happen? What will happen at the end?
Lordship, at the end, Lordship, my property should be Lordship.
So have you made good the loan amount?
Yes, already.
With interest.
Already, Lord. With interest, Lordship. Excess amount.
When did you pay that?
Lordship, last amount, Lordship, more than 27 lakhs.
Amount you have paid, I think it is 25 lakhs.
27, subsequent
27 lakhs.
Including this 13 lakhs, Lordship, as Lordship pointed out, and that 27 lakhs. So that was the court's order, Lordship, along with interest. I have deposited the substantial amount, including the interest, Lordship. That
property was handed over to me.
Still, that is in my possession, Lordship. That is.
Possession, my lord, that aspect, my lord. The sale certificate was issued on 15/11/2021. And on
16?
15/11/2021, my lord.
11/20.
And actually by 3 months. And at page 10 of my counter, my lord. And registration was done. Sale certificate was registered on 17/12/2021. After 1 month and 2 days, my lord. That is Annex B by page 11. And thereafter, this writ application was filed. And if your lordship will permit me,
no, what Mr. Dodaya is making a submission that the entire amount, including the interest, the petitioner has already deposited.
Yes, ma'am.
So
that is,
and he is in physical possession. The vital aspect is two things: whether he has cleared all his dues or not. Number one, with interest, and number two, whether he's still in physical possession in spite of the sale deed. These two aspects, please answer.
Well, I may be permitted, my lord. He's not in possession because after execution of the sale deed, already mutation has been done. RO has been created in my
name. You not understand probably what my lord said. Physical possession.
Physical possession. I am in physical possession.
You are in physical.
Yes, my lord. On the date of registration of the sale deed,
no, lordship,
physical possession has been delivered.
That's the wrong statement. That's why, lordship, they are approaching that.
Your lordship also knows in the mutation proceeding, the possession is inquired into before the mutation is done.
You have stated all those things.
Yes, my lord. Yes, my lord. I have stated in my counter affidavit, my lord.
Where have you stated?
My lord, paragraph 7, my lord.
Counter affidavit on behalf of
opposite pattern 4. Opposite pattern 4, my lord. I am opposite pattern 4. Paragraph 7, your lordship.
Wait, let us see. OP4 counter affidavit.
Page number.
Registration lordship on 7.
Noting it to khali amar 2 and 3.
17/12/2021 lordship. I have given the detailed date chat lordship entire. Counter
at which page of the brief?
Paragraph 7, page 3.
No. That is your one.
Yes.
In the brief, what is the number? Page number that you have to see.
Page number, paginated in total bit.
May I place the paragraph?
Opposite party number 4 रो counter affidavit recorder अच्छी की केबे फाइल कर ले सेट में पछियाड़ छु एपि नाही कि सेठी भी नाही केबे फाइल कर ले हम कॉपी देछन
my lord,
Mr. Dodaya, you have received the copy.
In fact, lordship, that copy, I don't have that copy, lordship. Copy देना. Copy to copy to दे दूंगा.
Your debt chart is with us.
Lordship, I don't know
date to अच्छी.
Lordship.
चलो नहीं.
Date. I'm sorry, my lord, the date is not there. I'm serving a copy of the counter affidavit in course of the day.
Council सेटा affidavit original affidavit आसीवा दरकार ना नहीं आपन गोटे कॉपी दे देबे सेठी नथिबो केबे फाइल कले त किछ लेखि ना दी
affidavit को दिन करतेबे कि कोनटा करतेबे କେବେ ହେଇଛି? No, it has never been filed.
କୋର୍ଟ ରେକର୍ଡରେ ନାହିଁ।
ଆଜ୍ଞା
ଲର୍ନିଂ କାଉନସିଲ ଫର ଦି ପିଟିସନର କୁ କପି ଦେଇନାହାନ୍ତି। ଆପଣ ଆଫିଡେଭିଟ
I have also served a copy to the bank.
ଓ ଆପଣ ବା ସାମ୍ନାରେ କହୁଛନ୍ତି, ମିଷ୍ଟର ଦଳେଇ କହୁଛନ୍ତି ଆମେ କପି ଦେଇନାହାନ୍ତି। ତ ସେଗୁଡା ଆପଣ ଯାହା କହୁଛନ୍ତି ଆମେ କେମିତି ତାକୁ ଆକାଉଣ୍ଟ କୁ ନବୁ ଅନଲେସ୍ that is brought on record.
Now serving a copy on the bank is not important because bank is with you.
Since it is not there on record.
So କେତେ ମାସ ତଳେ କହିପାରିବେ କି ନା ଏବେ ରିସେଣ୍ଟଲି କରିଛନ୍ତି?
ନାଇଁ ରିସେଣ୍ଟଲି ନାଇଁ, it has been filed.
ନାଇଁ ଆପଣ ସେଠି କିଛି ବି ନାହିଁ, you do not have a semblance of your filing. With upon signature.
Date ପକେଇନାହାନ୍ତି, the concerned clerk has not put the date.
No,
date
signed that averments. Averments has not been signed by party.
Party ସୁଧାଂଶୁ वाला
Date ଦିଆହେଇନି।
ନାଇଁ date ଦେଇନି।
Left side ରେ type କରାହେଲା ବେଳେ date ଦିଆହେଇନି। କିଛି ନାହିଁ।
Then we are asking the office to, if it is filed, let it place and you give a copy to.
I'm sorry.
Let it come on 10th. Let it come. During course of heard Mr. S.K.Sahoo, land counsel for the petitioner, Mr. M. Balakrishna Rao, land counsel appearing for opposite party number 2 and 3, and Mr. S.K.Sahoo, land counsel for the opposite party number 4. And the land counsel for the opposite party number 4 submits that he has counter affidavit. Since the same is not on record, let the registry place the same on record. Let a copy of the counter affidavit be also served on the land counsel for the petitioner during course of the day or by tomorrow.
In course of the day.
In course of the day. Put up this matter on 10th September 2020.
Can you do 12th lordship?
12th
Lordship.
on 12th September 2020.
Interim order continues.
Interim order is there and interim order to continue. Yes. अच्छा ऊपर लिख दूं तो Mr. Dolly files the date chart which is taken on record.
ସେଟା ଆମର already sir ଅଛି। ସେଟା scan ହେଇକି record ରେ ଅଛି। Date chart is already with us. That is with us.
ଆଜି ଫାଇଲ
ନାଇଁ
ଆଜି ଫାଇଲ କଲେ
ଅଛି page 129 ରେ ଅଛି।
Along with rejoinder, he had given a date check.
Along with rejoinder,
Rejoinder I have given.
Rejoinder.
There is some date is missing. Important date that will also I grateful.
All right. Serial does not 17.
Weekly list, item number 17.
17 पर हमारा इतला से जो ये था 17 ललित सब
You come to Annexure 6. That order which you are challenging.
Read my
Yes. Just you come to that basing on the prayer of the petitioner and the adoption, then from the copy of the ROR, say it from
the copy of ROR, voter identity card and Aadhaar card filed by the petitioner on 17/5/2024 during hearing, it is ascertained that the petitioner named S.K.Sahoo Hon'Ble Sahoo is the resident of village Khasbahal, Sautala, in the district of Bolangir. He has purchased acre 0.02 decimal homestead land in village Kumiapalli, Leasing, district Bolangir in the year 2010, and the land was muted in the year 2013 by the mutation case number 8/45 of 2013 of Tahsil Leasing as a holding number 106/429 of Kumiapalli. Much prior to this transaction, the people of the locality, more or less well aware about the commencement of the lordship till irrigation project, and some of them have purchased small extent of land.
Some of them have purchased a small extent of land, yes.
Small extent of land with intention to get rehabilitation assistance benefit. The petitioner is Ausubir to village Kumiapalli as reversed from copy of Aadhaar card and voter identity card submitted by him during process of hearing held on 17/5/2024. The petitioner is not losing his livelihood in the village Kumiapalli by acquisition of acre 0.02 decimal of land which was purchased by him in the year 2010. The authorized survey agency, Not Global Survey LLP, NLDP, has therefore excluded the name of the petitioner in the socio-economic survey of village Kumiapalli under Lower Suktil Irrigation Project, Bolangir. In such circumstances, the claim of the petitioner for inclusion of his name as affected family is rejected, as he is not losing their livelihood by acquisition of the land aforesaid acre 0.02 decimal of land for which he has already received the compensation from the competent authority.
So this particular line, that much prior to the transaction, the people of the locality more or less were aware about the commencement of lower irrigation project. So that is the exact reason why we asked you to produce the relevant notification issued under section 11. You have produced that. Order dated is notification is dated 29th June 2020. So your submission is that since you purchased it in 2010, land was mutated in 2013. So in 2022, this notification came. So therefore, you are entitled to get. But the rejection order indicates that you do not belong to that particular village, that is Kumiapalli, and you are not losing your livelihood by acquisition of that small patch of land, 2 decimal of land. So now let us see, you are citing those provisions yesterday. So this is obviously governed by this 2013 Act, right? So 2013 Act, you showed us the definition of affected family. And that is in 3C.
And he is coming under 3C Roman I.
You say that you come under 3C Roman 1. Right? That means affected family includes a family whose land or other immovable property has been acquired. So 2 decimal has been acquired. So you meant to say that plain and simple, this is affected family. But something else is there in that very act that merely because some land has been taken away, you may get the compensation, but so far as this rehabilitation assistance benefit is concerned, in what case you are to get it? So merely because you are a resident of other village, other place. So merely because you have a small patch of land in a particular village which is acquired, right? So you may get the price of the land, but not the benefit under the, unless there is material that by acquisition of that land you are losing your livelihood. How do you satisfy?
Kindly see my lord. 3C Roman II. My livelihood is concerned, my lord.
C3.
C Roman 2 II. Livelihood. I read, my lord. The family which does not own any land, but a member or members of such family may be agricultural laborers, tenants, including any for the tenancy or holding uncertain right, sharecroppers, or artisan, or who may be working in the affected area for 3 years prior to the acquisition of the land, which primary source of livelihood stand affected by the acquisition of the land. He also treated as a affected family. I want to
No. Your livelihood is affected by this acquisition. That you have to substantiate. For acquisition, you have already been compensated. But for other relief, as Mallard is saying, you have to say, you have to substantiate that because of this acquisition, you are losing your livelihood.
ଆପଣ ଗୋଟେ ଜମିଟାକୁ ଗୋଟେ ଗାଁରେ କିଣି ପକେଇ ଦେଲେ, ସେ ଜମିଟା acquisition ହେଲା. In that process, you are not losing your life. Suppose ଆପଣଙ୍କର ସେଇ ଜମିଟା ହିଁ ହଉଛି source of livelihood, ଅର୍ଥାତ୍ ତାକୁ ହିଁ ହଳ କରି ତା ଦେହରୁ ଯୋଉ ଇନକମ୍ କରୁଛନ୍ତି ତା ଦେହରୁ ଆପଣ ଜୀବିକା ନିର୍ବାହ କରୁଛନ୍ତି, ତାହେଲେ once that is taken, it can be said that your source of livelihood is taken away. So in that case, you are entitled to get this. Not that merely you can take a. So you have not. Your pleading is not that all.
Yes.
ଯାହାର ଜମି ବି ନଥିବ ଯଦି
yes, correct. ଜମି ବି ନଥିବ କିନ୍ତୁ ଜମି ହଳ କରିକିରି ତା livelihood ସେ ପାଉଥିବ, ସେ ବି ପାଇବ. That is what is.
I am also simple land user only.
No. You are. What is your, as said, what is your pleading? That you are losing your livelihood by this? In what way you are using the area? Were you cultivating it or you were getting the result of that?
Similar judgment my lord, actually
judgment comes later.
Factual aspect, ଆପଣ case ଟାକୁ ଆଗେ pleading ରେ establish କରିବେ ନା judgment କୁ ପଳେଇବେ? ଯୋଉ statute ରେ ଯାହା କହୁଛି ଏଇ category ଆସିଲେ ଜଣକୁ affected family ବୋଲି declare କରାଯିବ ଏବଂ ସେ rehabilitation ପାଇବ, ତା ପାଇଁ pleading ଟା ରହିବା ଦରକାର writ petition ରେ, ନା ଖାଲି judgment base ହେଇଗଲେ ହେଇଯିବ? pleading ଯଦି ନଥିବ ଆପଣଙ୍କର, ତାହେଲେ କେମିତି ଆପଣ ଇଏ କରିବେ?
I have also I have take the pleading only land user.
That is not the pleading. You have to substantiate that by cultivating from the land you are getting this income, or that is the only source of livelihood by utilizing the usufruct. Nothing of that sort. But you had a land, piece of land, for that you have been compensated.
Similar, also affected family also get the.
That may be incorrect. Why should you go?
ଆଗରୁ ଆସିଥିଲେ ରିଟ୍ ପିଟିସନ ଟେ ଫାଇଲ କଲେ, ରିଟ୍ ପିଟିସନ ଆପଣଙ୍କର ଡିସ୍ପୋଜ ଅଫ ହେଲା, ସେଠି ଆପଣଙ୍କୁ ଅପରଚ୍ୟୁନିଟି ଅଫ ହିୟରିଂ ଦିଆଗଲା, ଆପଣ ଡକୁମେଣ୍ଟସ ଫାଇଲ କଲେ, ଏଇ ସବୁ ଭିତରେ ଆପଣ ଯଦି ସେତିକି ଜିନିଷ ଅଥରିଟିଙ୍କ ନୋଟିସକୁ ନ ଆଣି ପାରିଲେ ବା କନଭିନ୍ସ ନ କରେଇ ପାରିଲେ ଯେ ଦ୍ୟାଟ ୱାଜ ୟୁର ସୋର୍ସ ଅଫ ଲାଇଭଲିହୁଡ କ୍ୟାଟାଗୋରୀ ଭିତରକୁ ଆଣିବାକୁ ହେଲେ, ତାହେଲେ କେମିତି ଆପଣ ରିଲିଫ ପାଇବେ? ଆପଣ ଅପରଚ୍ୟୁନିଟି ଦିଆହେଇନଥାନ୍ତା ସେମାନେ ୱାନ୍ ସାଇଡେଡ ଡିସାଇଡ କରିଦେଇଥାନ୍ତେ ମ୍ୟାଟର ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର। ତ ସବୁ ଜିନିଷ ସିଏ ଆପଣ ଯୋଉ ଡକୁମେଣ୍ଟ ଦେଇଛନ୍ତି ତାରି ବେସିସରେ ସିଏ ଅର୍ଡରଟା ପାସ୍ କରିଛନ୍ତି। So how you now say that you are coming within this particular Roman 2, you say?
Roman 2 is, my lord, another. He is not the landowner, only the livelihood is affected. Like the
ଆପଣ ଯୋଉ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଥିଲେ ଯାହା ବେସିସରେ କନସିଡର ହେଲା ସେ ରିପ୍ରେଜେଣ୍ଟେସନ ଏଗୁଡାକ ଉଲ୍ଲେଖ କରିଥିଲେ ଆଜ୍ଞା ମୁଁ ତାକୁ ସେ ଜମିଟାକୁ ଚାଷ କରୁଥିଲି ତା ଦେହରୁ ଏମିତି ଇଏ କରୁଥିଲି ତାକୁ ନବା
Yeah, Tali, you are not entitled. That is not the criteria.
the criteria is something else.
That is a livelihood you are not. Homestead land you are saying. How can you get? For that you have been compensated.
Mr. Das, these are the provisions or any other provision?
କାଲି ଯୋଉ ଦେଖୁଥିଲି Schedule 1 and Schedule 2 ଯୋଉଟା କି my lord was referring to livelihood ଉପରେ ସେ ତାଙ୍କର ପ୍ରେୟାର ବେସିକାଲି ପ୍ଲେଡିଂ ହେଲା ଯେ ଆମକୁ Schedule 2 ଅନୁସାରେ ଦିଆଯିବ। Schedule 2 ରେ ସେ ଆସୁନାହାନ୍ତି because livelihood
Schedule 2 ଟା କୋଉ ପେଜ ରେ?
my lord kindly
Yes, 77.
80 page
75 onwards, 76, second schedule 77.
ତାଙ୍କ ରିପ୍ରେଜେଣ୍ଟେସନ ଟା କାଇଁ ଯୋଉଟା ଦେଇଥିଲେ ଏଇ ଯୋଉ annexure 4 series
Annexure 4, my lord.
ହଁ
Annexure 4.
ହଁ ଏଟା 4 series ଲେଖିଛନ୍ତି।
Schedule 2 ରେ ବି ଆସୁଛି କଣ ନା in addition to the first schedule also they will get if their livelihood and loss of the land
Law is that livelihood.
First schedule, my lords, as per the section 31(2) is not applicable to the affected person. Section
You
31.
come to your annexure 4 series, page 19, that representation. You have specifically mentioned that they have acquired your homestead land.
Yes.
So there is no question of any agricultural land. Depending on that, you are plowing that land, earning something. That is how it is taken away, and your source of livelihood. That is nothing. Which you are there in that Roman 2.
Roman 2 is not the landlord, but the landowner, my lords. I am the landowner, landlord. He is the Roman 2 is not the landlord, but he has livelihood is affected.
Yes, 16 that was annexure भी on page 16. 15 was annexure 2. Then I got notice it our bank पैसा. And next page 16 रे next का है कौन सा plot number घरवारी
Loan compensation, loan value has already been paid.
ଘର ପାଇଁ ଆପଣ compensation ପାଇଯାଇଛନ୍ତି।
Loan value ତ ମୁଁ ପାଇଯାଇଛି।
ହଁ land value ପାଇଛନ୍ତି।
Similar
এটা schedule 2 ରେ କଣ ଦେଖିବାକୁ ଚାହୁଁଛନ୍ତି?
no schedule 2 is
second schedule
my lord.
for heading the madam this manner elements of the rehabilitation and resettlement entitlements for all the affected families bracket of both landowners and the families whose livelihood is primarily depends on the land acquired in addition to those provided in first schedule. And the first schedule is compensation for landowners.
Yes, land council, what you saying?
Section 31 is say that मतलब first schedule, section 31(2), the rehabilitation and resettlement award shall include all the following, namely, last mile provided that in case of any of the matters specified in under clauses A to K are not applicable to the affected family, the same shall be indicated as not applicable. So I am not coming under the first schedule rehabilitation assistance compensation method.
Yes. What amount you have received?
5,29,962 total.
Similar judgment knowledge affected family also get the benefit of the affected compensation, affected family compensation. One judgment. Maybe 2006 policy.
He is going to 2006 policy. He is coming to country and he is going to 2006 policy.
Which paragraph is that?
The paragraph 5 knowledge is paragraph 5 knowledge is 344. That animal the undisputed fact of the case are that father of the petitioner had purchased acre 3 acre 15 decimal of land from Ghasiram Dambo by registered sale deed 569 dated 10/3/2013 and acre 4 acre 0.
No, you are claiming in 2006 policy or 2013 policy?
Similar.
Not similar. Your policy is different, sir. Why are you taking us to 2006? This case is altogether for 2006 policy. You are claiming your
2013.
in 2013. Then how do you expect this? Your policy is altogether different. There might have been increased in the compensation in 2013. Many criteria are there. How can you equate in 2006? Is it there the criteria that the livelihood should be there in 2006 policy?
No, my lord.
Then here is a plug for us.
Here is the livelihood is not
Here
affected.
the definition is very clear. Who could be taken as an affected person of affected area? It is well defined here. And you have availed a part of this also in 2013 policy. We cannot now go back to 2006 policy.
The petitioner, S.K.Sahoo, has filed this expedition for quashing the order dated 17/5/2024 passed by the project director Lower Sakter Irrigation Project, Balangir, opposite party number 5. In holding that the claim of the petitioner for inclusion of his name as affected family is rejected, as he is not losing his livelihood by acquisition of acre soon 02 decimal of land for which he has already received compensation from the competent authority. It is further prayed in this petition for a direction to the opposite party number 5 to release the affected family's compensation in favor of the petitioner within a stipulated period. The petitioner earlier approached this court in WPC number 9484 of 2024. For a direction to the opposite party number 5 to consider his representations and to insert his name in the affected family's compensation list and release the amount in his favor within a stipulated period. This court by order dated 22/4/2024, without expressing any opinion on the merits of the case, disposed of the writ petition directing the opposite party number 5 to consider and dispose of the representation filed by the petitioner and to pass appropriate order. In pursuance of such order, the petitioner not only produced the certified copy of the order before opposite party number 5, but also filed some documents like ROR, voter identity card, Aadhaar card during course of hearing. After going through the documents, the opposite party number 5 found that the petitioner is a resident of village Khas Bahal under Saintala police station in the district of Balangir, and he purchased Ekorsun 02 decimal of homestead land in village Kumiapalli under Luisinga police station in the district of Balangir in the year 2010, and the land was mutated in the year 2013 by mutation case number 8/45/2013 by Tahsildar Luisinga. The project director, opposite party number 5, was of the view that much prior to the transaction, the people of the locality more or less were well aware about the commencement of Lower Software irrigation project, and some of them purchased small extent of land with intention to get undue rehabilitation assistance benefit. It was found that the petitioner is an outsider to village Kumiapalli, which is revealed from the copy of the Aadhaar card and voter identity card, and it was held that the petitioner is not losing his livelihood in village Kumiapalli by acquisition of acre soon 02 decimal of land which was purchased in the year 2010. And therefore, it was held that the authorized survey agency, Mart Global Survey LLP Noida, bracket UP, rightly excluded the name of the petitioner in the socio-economic survey of village Kumia Pali under Lower Saktel irrigation project. The Land Council for the petitioner submitted that since he purchased the land in the year 2010 and it was mutated in his name in the year 2013 and the notification was of the date 29/6/2022, which is produced before us. Therefore, much prior to the notification under section 11 of the 2013 Act, the petitioner had purchased the land, and therefore, since the land has been acquired by the authorities in terms of section
11.1 probably.
11.1.
11.1.
Section 11.1. The notification. Section 3 C1 Roman 1 and Roman 2 is entitled to be treated as affected family, and therefore the benefits under the 2013 Act should have been provided to him. The crux of the matter is whether by acquisition of the land in question, the petitioner has lost his livelihood or not. The representations also, the ROR clearly indicates that it was a homestead land, and the petitioner in his representation has also mentioned that the authorities have acquired his homestead land. There is no averment at all, either in the representation or in the petition, that by acquisition of the land in question, the petitioner has lost his livelihood. Admittedly, the petitioner is not a resident of that village, which should be evident from the Aadhaar card as well as voter identity card. Therefore, even though he had purchased the land in the year 2010, which was mutated in the year 2013, that is much prior to the notification under section 11 of the 2013 Act, which was published on 29th June 2022. Since there is no material before us that the petitioner has lost the livelihood, and since he has already received compensation for the land from the competent authority, we are of the view that the opposite party number 5 is quite justified in holding that the petitioner is not entitled to the rehabilitation assistance benefit. In view of the foregoing discussions, we find no merit in the writ petition, which is accordingly dismissed. Same model in the other case.
Both were similar.
Next.
Item number 18.
My Lord, on 27/8, while hearing this matter, my Lord, may kindly see, my Lord, may directed me to produce that order dated 19/3/24. My Lord, may kindly see the order dated 27/8.
29/8/2024.
27/8/24. Last one.
No, that is 29/8. 29/8. That is the order number 1. During course of argument, Mr. R.N. Mistral and an additional government advocate appearing for the state referred to the order dated 2/7/2024 under Annexure 9, which reveals that basing on the order of this court, field inquiry was conducted by Revenue Inspector Chandaka in mutation case number so by letter number so accordingly. By letter number so the Revenue Inspector Chandaka reported that the land is in possession of the petitioner lying fallow with boundary work and the same is not used for agriculture purpose. Land senior advocate appearing for the petitioner, on the other hand, drew the attention of this court to Annexure 5, which is the inquiry report submitted by Revenue Inspector Chandaka dated so to Tahsildar in connection with so. Okay. It is apparent that the mutation case number reflected in Annexure 5 and in Annexure 9 appears to be different. Let the Land Council for the state produce the report of the Revenue Inspector Chandaka in connection with mutation case number 5899 of 2024. Put up this one. Say,
No, I've got the. But my lord, I have discussed that. I will file an affidavit because there are certain other discussions.
And give a copy to Mr.
Yes, ma'am. I can file the affidavit in course of the week.
Next week.
My only agony is that this petitioner is having to come to this, your lordships, to rescue him. This has been happening since 2007-8. Firstly, his lease was cancelled under 7A3 of the OGLS Act. That was set aside by your lordships. Thereafter, my lords, in the next round, in the settlement operation, again the land got recorded in the name of the government. That has been set aside by your lordship. Thereafter, they did not, even your lordship directed the land be recorded in her name. The Tahsildar delayed the proceeding for which a contempt application had to be filed. During pendency of the contempt application, the mutation was done and the court was informed. 2 days thereafter, the resumption proceeding was started. And in this resumption proceeding, land is sought to be resumed on the ground that it is not being used for agricultural purposes. But this is one of the rare cases where the petitioner has been utilizing the land for the purpose it was leased out. In fact, the lands in Andharua, your lordships would be aware.
No, Mr. Mukherjee, the document which you saw, in which the report of the Tahsildar is also there,
yes,
that it is being used for agricultural land, that relates to a different patch of land.
My lord, it does not relate to a different patch of land, it relates to the same patch of land. In fact, I will show to your lordship, let them file the documents. Let them file the documents, your lordship may fix a short date.
No, it will come next week. There is no question of that.
I will have it by Thursday.
All right.
By Thursday, so that I'll get it with a copy to
Land Council for the state submits that as per the order dated 29/8/2024, he has received instruction from Revenue Inspector Chandaka in connection with mutation case number 5899 of 2024, which he intends to file by way of an affidavit. Let the copy of the affidavit be served on Mr. The land senior advocate, Mr. Mukherjee. During course of this week, matter be listed on 11th of September 2024. Yes, Mr. Mukherjee.
Okay.
Item number 19.
Yeah.
19 million. Our representation under Annexure 3 is pending before the opposite party not 2 million for constitution since 8/4/2020.
Opposite party number
2 million.
Opposite party number 2 representation is Annexure 3 to be disposed of. This is item number 90.
Within a stipulation.
Yes,
Within a stipulation.
Yes, 3 months. But
Item number 20.
land acquisition for the deciding here is not challenge matter. Annex of 5 series, the petitioner, the owner is a recorded tenant investor to the agricultural land. The similar matter and similar issue has been raised in another writ petition, my lord. Earlier writ petition, my lord, had issued notice and the matter has been kept to 17th September, my lord. This is the order, my lord, sir, passed the order issuing notice to the
Extend the order for the opinion.
notice has been issued to the
Yes,
opposite.
Let him go through it. Take the order.
Batch of matters have been filed, my lord. That has been batch of matters are there, my lord. My lords have posted it to 17th September.
এই যে অর্ডারটা আছে সেই টাইপর করদেবে এবং this matter along with so and so করদেবে
And also to obtain instruction in this process.
ଯାହା ଅର୍ଡର ଅଛି ସେଇଆ ଲେଖାଯିବ
Obviously. Let the analogous hearing. Yes, sir.
Yes, ma'am.
Item 21.
May I please, Lord, sir. I am permitted to submit on behalf of Mr. Samantra. I'll have memos. The petitioners are the legal heirs of the purchaser who purchased 150 decimals of land from the lessee. The lease in question was granted in favor of the lessee on 10/11/1974. And a proceeding on section 783 of the OGLS Act was initiated in the year 1998. Pursuant to that proceeding, my lord, the lease was earlier cancelled on 28/7/98. 88 is a mistake in the date chart, my lord. And I had challenged it earlier on in OGC number 13405. Madam?
That is your debt chart?
To the writ petition, madam. Enclosure B.
Just a minute.
Debt chart on behalf of the petitioner. So in that writ petition, our contention was that the purchasers were not noticed. So therefore, also remitted the matter back to the Tahsildar that we should have it before passing before the proceeding, my lord. Thereafter, by the impugn order under Annex 2, my lord, the lease was cancelled. When cancelling the lease, it was held at page 17, my lord. That on account of the apostate in grant of lease of the case land in favor of the original lessee named Ramesh Chandra Behera in WL case number so and so by Tahsil Bhubaneswar is illegal and invalid. Hence, I have no option but to declare the lease cancelled. As the lease of the land is illegal, the subsequent transfer of the land to the petitioners are void. This order I am challenging my on the ground that the proceeding was initiated after 14 years. After 24 years, man.
Just come to that very page where it is mentioned that CR does not say to form,
but the CR does not record.
Yes. You proceeding the CR does not record any such proceeding. Rather, it shows that is important.
Yes. It shows the haste in which the lease has been granted.
Yes.
But by some
just
yes.
Please.
The case was instituted on 28/8/1974 and the land was settled on 11/10/1974 in 45 days. Such haste and non-recording of a proceeding together with non-availability of a documentary proof brings to surface the violation provisions of the Act and the rules by the Tahsildar in settling government land in favor of an ineligible person whose case had no merit. Moreover, verification application by the lessee show that classification given land was Shudjangal, which is not tenable in nature.
Which is not leasable in nature.
Not leasable.
Yes.
Chota jungle, yes.
Grant of lease of forest system land by Tahsildar proves violation of Act 1 of 1948, which imposes restriction on use of forest land. Then he quoted some provisions of the Forest Conservation Act and has held that the lease was cancelled and consequently transfer by the lessee in our favor was held to be void.
Yes.
My submission is that document kindly see the next page, page 18, annexure 3, by which section 783 was amended. The proviso to the last two paragraphs. The proviso to subclause B of section 783 provided further no proceeding under these subsections shall be initiated after expiry of 14 years from the date of the order. Admittedly, the lease was granted in favor of the lessee in the year 74. It is also the admitted case that the proceeding under 783 was initiated in the year 1998. By that time, 24 years have already elapsed. So therefore, no proceeding could have been initiated.
Now let us see that OGL starts. No, if it goes to the very root of the matter, if the authority is not empowered to grant lease in favor of a land which is recorded as Chota Jungle, then that goes to the root of the authority lacks jurisdiction. So in that case, do you mean to say that merely because it was
by limitation?
Let us see that.
Section that in fact, new act is also will not find that new book that was again further amended, deleted in the year 2013. That old book is there. In fact, for which I have enclosed the notification on Annex 3. In fact, old book it is there. Also kindly see. That 14-year period was deleted in the year 2013.
Achha.
So therefore, that provision will not be available in that case.
So now when the order was passed?
Order was passed in 2014.
So by that time, what?
No, my submission is that the initiation of the use of jurisdiction.
No, the order was passed in 2000.
The initial order was passed in the year. Initial order cancelling the lease was passed on 28/7/98.
Oh, that's a different matter. We are now. You are challenging a order of dated 2/8/2014.
Yes, ma'am.
You yourself says that in 2014, 13,
that 14,
this order was passed in 2nd August 2014.
Yes, ma'am.
Since in 2013, that
was deleted.
That was deleted. So how you say that after 14 years this authority cannot?
No, the language employed in the clause is no proceedings shall be initiated. So therefore, the proceeding was initiated in the year 98, by which time 28 years have already passed. The number of the proceeding being RC number 852 of 98, page 14, annexure 2. So by the time, so
what is the number of that case?
Revision case number 852 of 1998.
That is annexure 2, page 14, at the top.
Yes, yes. This proceeding, when you approached this court in 2001, this proceeding was pending. So that is how this court, by order dated 17/10/2001, directed for expeditious disposal.
In fact, 98 earlier it was passed, it was cancelled. I approached Lordship. Your Lordship remitted the matter, set aside that order and remitted the matter back to the Tahsildar on the reasoning that we were not noticed by the Tahsildar before cancelling.
It's all right. Now the proceeding revision case number is 852 of 1998. and it was subjudiced, and there was delay in disposal for which you approached, as it appears from the influenced order, that on the basis of the order passed by this court, ultimately this annexure 2 was passed, right?
Yes.
So
My submission is by the time it was initiated, 14 years had already elapsed. Initiation was in the year 98.
What was the provision in 1998?
98, madam.
Yes.
This was the provision, 14 years. This was the provision, the annex of 3. That came to be deleted in the year 2013.
Just a minute.
No, which one is the cutoff date from which you are recalling the date of the year of 14 years?
From the date of the grant of the lease.
That is 74.
74, initiated in the year 98. By that time, 24 years had already passed. More than 14 years.
Except fraud and misrepresentation.
It was
No, we want to see that particular act after amendment, how it reads like. Not this by the way of this annexure 3.
Yes.
Let us see that.
Yes, this book is there now.
Seventh A.
Next page. Find that provision next page.
Section 3. Provision A. In subsection 3, after the words fraud or misrepresentation, provided further and no proceeding under this subsection shall be initiated up to the upper expression. Checklist on the account of any irregularity of this year. Government may, by notification, the official visit authorize any official not below the rank of sworn with the reserve and cash which has been reserved from any official authorized counsel can have power to be reserved and such that any portion that satisfy the by southern extension to reasonable employment past and the system so on so this is the proceeding on their own. This is the proceeding on own motion, na?
Yes, ma'am.
So the date of order is according to you? Date of order.
Of the lease,
Yes.
that is,
Have you mentioned in the repetition?
yes, sir.
Page paragraph number?
WL case number 1668 of 1974.
Paragraph 3, page 3.
The date is 11/10/1974.
Yes, sir.
Okay, 11/10/1974. And this proceeding was initiated in that
year 98, man. The exact date I cannot tell, man.
it is that is number has been given, so obviously it is 98.
Man.
WL division case number 85/90. So obviously it is much after that. This is almost 24
years.
24.
In fact, there are a large number of decisions on this one. The Honorable Chief Justice Zaverian, that is 2018 to OLR, page 101.
It is uncertain, but apparently the one thing is that these persons on the they use them to put a job of this
So how do you meet it, my lord? I am aware of that decision, my lord. It started from 2006 Purna Pradhan case. And now recent cases how to Paltan 6 also 2023. But the crux of the point is, my lord, that fraud and misrepresentation if there is, then this embargo 14 years would not be there.
It's now that the embargo has been lifted. That was there in that when the this case was instituted. In that is exactly now it is not there for the fraud,
but it was still there till 2013 year.
Right, 2013 ଆପଣଙ୍କର proceeding initiate ହେଇଛି 1998 ରେ ହେଲା ଆପଣଙ୍କର ଏଇ ଯୋଉ lease ଦିଆ ହେଇଛି 1974 ରେ. So obviously it is after 24 years.
But if that lease out property is proper, because that was a jungle that absorbed by the RDC also, man, that was a chota jungle. It cannot be leased out to any person without
that is exactly suppose your officer has committed some irregularity, let us say, and you want to exercise the so motu revision power. Question is that you can do so, but the time limit that is prescribed under the act is 14 years. So it is not for an indefinite period. When the legislature fixed that time limit, it must have thought of that why it is to be so fixed.
But
okay,
in that case, fraud or misrepresentation practice,
all these things have been stated there that the collector
that includes fraud and misrepresentation.
Everything has been mentioned there.
Chota jungle, and whether he was landless person or not, that was also not there. That is
whatever the question is very simple. His power is not lacking with the collector. In case of fraud, misrepresentation, material irregularity, the collector can initiate a proceeding and also give an opportunity of hearing, then he can pass appropriate order. The question is that when that power can be exercised, when that proceeding, so when it was instituted, suppose let us say we pass the order, quashing because on this ground, let us say that is. Suppose now you again initiate the proceeding. If a proceeding now initiated for a for similar thing, so now there is no time limit. But at that time, there was a time limit of 14 years.
That time that was there. A rider was there. If a fraud or misrepresentation of fact is there, then this rider will not come to it. There is 14 years embargo.
Where is that?
I will come with the decision.
The
Let it be
decision is
taken up
authorized,
next.
decision is authorized, my lord.
That is there. That is always there. We don't know how these limitations, this will override in the event. But here the Act says it includes. Here the power includes.
But in one case, you can find that yes, fraud has been committed, but that can be taken into account from the date it is brought to the notice of the. It is not that from the date, right? So that is the relevant thing. So once it is brought to the notice of the man, but the authorities slept and 14 years passed in the meantime, then they started initiating the proceeding. Then perhaps this proviso, you examine, you can find the decision in that light. So the question is that when that
it came to the notice of
the collector. So this matter notice has been issued. So issue notice on the question of admission, indicating therein that the matter shall be disposed of.
Sir, only the opposite party will receive a copy.
The Learned Counsel for the state accepts notice on behalf of the opposite, all the opposite parties. Let the copies of the writ petition be served on the Learned Counsel for the so on so by within a week. Matter will be listed in the week commencing from here. 30th of September 2024, the Learned Counsel for the state shall file the counter affidavit in the meantime. Just write it so that it will be here. That Learned Counsel, Mr. Thor.
Well, I'm filing
Mr. H.M. Dhar, Learned Counsel, filed the appearance memo, which is taken on record. He submits that in the case in hand, the WL case number 1668 of 1974. The Tahsildar, opposite party number 3, in WL case number 168 of 1974, granted lease in respect of the scheduled land for the in respect of the scheduled land in favor of one Ramesh Chandra Behera, by order dated 11/10/1974, and the lessee Ramesh Chandra Behera sold the land in favor of the petitioners.
In favor of 4 purchasers, I purchased a part of.
Acha, in favor of 4 purchasers, and the petitioners purchased a portion of the leasehold property from one of such purchasers, namely Subrat Kumar.
No, Subrat Kumar Mahanti was the purchaser. I am the legalist. He has died in the matter.
Through his legal. Through his legal.
To his legal heir. To the legal heir of the purchaser. And the sale deed was executed on 7/11/1984. It is the contention of the Land Council for the petitioner that 24 years after the grant of lease in favor of lessee Ramesh Chandra Behera by the Tahsildar, a proceeding
was initiated for cancellation of the lease in purported exercise of power under 7A3 of Odisha Government and Odisha Government Land Settlement Act 1962. Stop. Mr. Dhar referred to the proviso, second proviso to 7A3 of 1962R, which indicates that no proceeding under this subsection shall be initiated after the expiry of 14 years from the date of order. The Land Council submits that even if the order was passed under a mistake of fact or owing to fraud or misrepresentation or on account of any material irregularity of procedure within 14 years from the date of passing the order, and in the case in hand, since the proceeding has been initiated 24 years after the lease was granted, the same is not in consonance with the aforesaid provision. Reliance has been placed in the case of Lakshmidhar Tarai versus Collector Puri, reported in 2018, Volume 2, Orissa Law Reviews 1012. Issue notice so and so put up this matter on ground. Yes.
And filed an application for stay, that is live.
All right. The IN number so and so filed for stay of so and so. Issue notice खाली करता हूँ. Okay, monitor the program. Put IN filed in court, let it be registered. Also issue registered. Yes.
Number 22.
Two, I have directed to take instruction from the collector and the collector have received the instructions. Suggest about the collector is not visible.
Which order? Order number? We passed order on 21/8/24. Just let us go through the order. Petitioner has filed a said petition was the later dated so and so of the land acquisition zone officer Putta, opposite party number 1 under annexure 5. Main contention that has been raised by the Land Council for the petitioner is that two plots which have been mentioned in the notice dated so and so under annexure 5 was not there in the notification issued under section 11 of the so and so 2013 Act. Since there is a time gap of more than 4 years between the notice dated 26/2/2020 and 15/7/2024, Land Council for the state seeks some time to obtain instruction as to how the two plots which were not there in the notice dated so and so came to be included in annexure 5. Yes, that was it. Next week.
17.
All right.
My lord, I humbly submit that in the meanwhile, my lord, stay may be granted, my lord. As my lord, I just want to bring your attention to Annexure 7, my lord. Annexure 7, page 48.
Yes.
My lord, after some portion of my land is being notified under the notification, my lord, after that I have sought permission from the collector on 9/5/2024 under the proviso of section 11 that the leftover portion of my land which is not under acquisition may be allowed to sold. In that, my lord, the collector, after seeing that, after perusing the documents, have given us permission that the leftover portion may be sold, my lord, which induced that the land has never been acquired, or because this as recent as 9/5/2024 I have been granted a permission.
If you want to sold, then again there will be further
multiplication of cases,
and the purchaser would be in problem.
My lord, I am the purchaser, my lord.
We'll see.
My lord, my vendor took this permission, my lord. After taking the permission,
sorted out. The Land and Council for the state submits that he may be given some further time in terms of the order dated so and so to obtain instruction of this matter on 17th September 2020. Yes.
Item number 23.
my lord, one last request, my lord. On the last occasion, my lord, on the order, my lord, the name of the advocate reflects as Suryakant Das.
Yes, yes, my lord.
Wherein, my lord, it is
Yeah,
it shall be
corrected. Yes, sir. Suryakant Das. So, कौन ने लिखा
My lord, Shashwat Kumar Acharya and myself, Krutivash Mohammed.
Item number 22.
Yes, my lord, yes.
अच्छा 22 रो से
8 रखा है जी। 8 किंतु शाश्वत है।
हाँ पिछले लिखा है सूर्यकांत दास ते ऑर्डर जो अभिषेक अग्रवाल पर जो पिटिशनर एडवोकेट का नाम सूर्यकांत दास लिखा है इसला সেটা পড়লে শাশ্বত কুমার আচার্য বলে
সেটা অ্যাকচুয়ালি পূর্ব আইটেমটা সেদিন যেটা ଥିଲା সেটা সূর্যকান্ত স্যারଙ୍କ ନାଁ ଥିଲା ତ সেটা পড়ে আসছে
আচ্ছা ও এইটা আছে শাশ্বত কুমার আচার্য হ্যাঁ yes next
Item number 23. May I please, your lordship? Similar matter was raised, my lords, earlier, and these matters are taken up along with that matters, my lords. That was adjourned to 17/2024. I think these matters may come along with this writ petition.
এটা আছে ন্যাশনাল হাইওয়ে ম্যাটার
Aye,
তো অমিতাভ দাস ଙ୍କୁ ଦେଇଛନ୍ତି କପି
aye.
ତା ନାଁ ତ ଅଛି
See, I just supposed to appear after this was taking off, but today what happened, I don't know.
so you just intimate since there is in the weekly list you can take up this matter tomorrow or the moment Mr. Das comes so just give a ring and tell that
Aye, aye.
okay ask him better okay
I am asking for on behalf of Mr. Das.
okay then he said that similar matters are
17.
okay 17925 all right the name of Mr. Amitabh Das be reflected in the cause list for the opposite party number 1 stopped. Mr. Das Land Council for the petitioner submits that WPC number 18954 of 2024 is identical matter and the said matter is posted to 17/9/2024 and this matter may also be placed on that day with said WPC with this matter on 17/9/2024 with WPC number 18954 of 2024. Yeah.
Item number 24.
My lord, I may be pardoned to withdraw with liberty to file in the appropriate authority.
What is your good name?
A. Das, Allah Das.
It actually works with all these three matters. Huh? Anand Das.
Allah Das.
Allah Das. He can go to memo. Mr. To file a memo.
My presence in meeting.
Huh?
In this matter, my presence.
We know. Mr. C.DASH Land Council appears for Odisha Gramya Bank. Mr. Allah Das Land Council appearing for the petitioner files a memo. Get account bill. What I told you. Is it a memo that is to be filed in that way? Right. File a memo. We have to file. Please write down the case number. Do not press this application according to this WPC disposed of at last. Yes. Okay.
Item 25. Item 26.
May I please, Your Lordship?
Yes.
My lord, the land under Annexure 1 is a Spritivan land having Kisam Chota Jungle, which is acquired by the Rengali right canal system, and there canal has been constructed and so the land has been used, but compensation has not been paid. I approached this honorable court where my application was pending before the competent authority. As per a direction of this honorable court, the land acquisition officer under Annexure 8 have disposed of the representation having observation at page 35. 10/5/2023 loan and government pleader Sri P.K. Lenka and loan and AGP Srimati Priyamoda Mishra are present. Loan and counsel Sri Keshanai is present on behalf of the petitioner. Sri Soresh Lokanath P.R. Sethi, Special Land Acquisition Officer, Rengali Right Canal System, Dhenkanal, is present and submits that though the private land of the petitioner recorded under Jhati Jungle Kisam has been acquired under the Rengali Right Canal project, but payment of a compensation could not be made yet in view of the instruction issued by the government in Revenue and Disaster Management Department by the letter number so dated 19/3/2019, in which it has been mentioned that clearance under Forest Conservation Act should be obtained from the Ministry of Environment, Forest and Climate Change or Government of India before payment of a compensation. Third, in view of the above submission, the Special Land Acquisition Rengali Right Canal System, Dhenkanal, is directed to take appropriate steps and pursue the matter for obtaining necessary clarification. Permission for payment of a compensation to the petitioner at the earliest. My respectful submission, my lord, in similar matters, similar having jungle, chota jungle kis, compensation has been paid.
We do not know when it is paid, but the notification is dated 19/3/2019. So that have you annexed that notification?
Yes, my lord.
Where is that?
Annexure 2, my lord.
Annexure
2, page 16.
This is no, that is not the notification. The notification is letter number.
Oh, sorry, my lord. That notification of the seeking permission from the Forest Department, my lord.
The this in page number 32, the notification that number has been mentioned, date has been mentioned. So have you seen what has been written there? You have prepared the writ petition, and on the basis of a particular letter, your claim has been torn down. Whether you have not, why have you not thought it proper to just give a glance to that letter, what has been written there? Have you got a copy of that letter?
Yes, my lord. Annexure 6. That is page 31, my lord.
What are you dealing with?
No. This is not the
Mr. Counsel, please come to Annexure 8, page 32. In 32, you just place the order dated 10/5/23. 10/5/23 रे collector गोटे mention करिसेंती जे government in revenue and DM department vide letter number so and so is mentioned that clearance of so and so should be obtained. Say letter or copy आपनो annex करी नहांती. Have you got a copy with you now?
No, my lord. I will no.
Mr. You may face difficulty. Why don't you obtain that letter?
All right. Letter is there. Wait. Kind.
କେତେ ନମ୍ବର ସେଟା?
କହୁନାହାନ୍ତି କେତେ ନମ୍ବର? 35 ଆମ ପାଖରେ ସମୁଦାୟ ଅଛି 32 ପେଜ ପର୍ଯ୍ୟନ୍ତ। 35 କୋଉଠୁ ଆସିଲା? ଆପଣଙ୍କ ରିପିଟିସନ ର ପେଜ ଟୋଟାଲ ପେଜ କେତେ ନମ୍ବର? କଣ ତା ଦେହରେ ରି ନମ୍ବରିଂ ଇସ୍ୟୁ? 35 ନୁହେଁ ଆମ ପାଖରେ 32। ଆଚ୍ଛା ସେଟାକୁ ରି ନମ୍ବର କରିଛନ୍ତି ବୋଧେ?
ଆଜ୍ଞା।
ତ 31 32 ଟା କରିଛନ୍ତି 34 35। ଆଚ୍ଛା କୋଉଠି ଅଛି ସେ ଲେଟରଟା?
That revenue and disaster management letter number 9269. ସେଇଟା ହୁଏ।
The petitioner P.R. Rahul has filed this petition challenging the order dated 10/5/2023 passed by the collector Cuttack under Annexure 8 in which referring to the instruction issued by the government in Revenue and DM Department Violator number 9269 dated 19/3/2019. The collector has directed the special LAO Rengali Right Canal System Dhenkanal to take appropriate steps and pursue the matter for obtaining necessary clarification, public permission for payment of compensation to the petitioner at the earliest stop. Let the Land Council for the state produce the aforesaid letter number so and so, and also obtain instruction as to how far special LAO Rengali Right Canal System Tenkana has proceeded in terms of the impugned order dated 10/5/2023 to obtain clarification of the permission for payment of compensation to the petitioner. Matter will be listed in the week commencing from 17th of 2024. This Special Land Acquisition Officer Rengali shall appear through virtual mode to answer our query at 10:30. Yes.
Item 25 held up in the lift, my lord. Item 25 ଟା ମାସ lift ରହିଗଲେ ପଡ଼ିଗଲା।
Yes, all that matter once again.
Item 25.
And copy of the order.
My lord, petitioner took a housing loan of 3,30,000, my lord. In the month of June, there is an overdue amount of 84,000. The lordship may direct that he will approach the authorized officer and deposit the overdue amount into installment, my lord. In page 31, my lord, the account statement, which shows that 84,563. Petitioner is a labor and the installment is only 10,080.
The remedy lies elsewhere. We are not interested.
The lordship may only I wants to approach the authorized liberty to approach the.
Yes, next disposed of.
Item 27.
27, my lord. On 21st, 2021, my lord decided to take instruction. I seek some time, my lord. That is 17.
What is that representation disposed of in court order of court today?
After instruction, compensation amount also.
Just a minute. You come to that annexure 9. That was the order passed by the ADM, Ganjam Chhatrapur. In that page number, annexure 9, just read that last second paragraph.
The Honorable High Court.
Yes, yes.
The Honorable High Court has passed order on 19/12/2017 and dismissed the above brief petition with a liberty to the petitioner to approach the land acquisition officer Ganjam to receive the compensation and also interest from the date of award till payment. As per the above order, this office has made calculation of the interest and communicated to the Commissioner of Commercial Tax, a Unified Check Gate, Girishola for placement of bond towards interest by this office letter number so and so and subsequent letter number so and so of Collector Ganjam to the Principal Secretary to Government in Commerce and Transport Commerce Department, Odisha for payment of the same along with the existing compensation money to the claimant. But neither the fund have been provided by the department nor the petitioner has ever approached this office for to receive compensation as per the.
No, he has stated that I have approached, but that was not sanctioned.
Madam.
So that is the
to take instruction, madam.
you are to take instruction. So many years have been passed. Otherwise, we will ensure the personal appearance of this district collector Ganjam.
And let it be on 17. I will get.
All right. The Learned Council for the state seeks for an adjournment for 1 week to obtain instruction in terms of the order dated 21/8/2024. Leave this matter in the week commencing from 17th September 2024. Yes.
Item 28.
May I please? Lords, for beautification of around the Lingaraj temple, the government of Odisha came up with a policy. May turn to page 71 of the writ application. They will acquire the land and compensation to be paid under Right to Fair Compensation and Transparency in Land Acquisition Rehabilitation Act 2000-2013. Now, Your Lordship may kindly turn to page 47 is the registered sale deed, which is of 1944, where I had purchased the land. Page 47. This is in Bengali. I have translated it, which is at page 57. Lordship, got it?
57, yeah.
57. Now, Kashinath Mukhopadhyay is the recorded tenant of the land. Now, your Lordship may kindly turn to page 64. Kashinath Mukhopadhyay, my name reflects Prajaranamam. Then your Lordship may kindly turn to page 75.
Kashinath Mukhopadhyay, so it is
Kashinath Mukhopadhyay is the predecessor and he is the father of the present petitioners.
Father?
Yes, 44 sale. Yes.
Kashinath Mukherjee lekha hai ki?
Mukhopadhyay, Mukherjee are same. Yes, yes. Now, this page 75, I raised an objection. Application for compensation and submission of form. We understand we are the undersigned are the legal heir of Kashinath Mukhopadhyay, residing in Kolkata. All are above 70 years of age and want to willing to participate. Submitted application and necessary document for the compensation under the scheme. The government which came to. These are the property details. Then a Lordship come to page 79. I sent a email because that time it was COVID and was not on my part to travel from Calcutta.
Ultimately, what has happened?
What has happened now without paying the compensation? This is the most important part. The Lordship may kindly turn to page number 120. They did not pay the compensation to me despite asking them that I am the owner and what their action is. Your Lordship may kindly see. That is at page. How they have hand in gloves with. Page 117 is the non-payment of compensation. Now, then your Lordship may kindly come to my grievance at 120. This is to S.K. Ponda, PRO to CM, Lok Sabha Bhavan, Sachivalaya Marg, and then page 122, they transfer my grievance to the Deputy Commissioner, Bhubaneswar Municipality, grievance by petitioner Buddhadev Mukherjee regarding non-payment of compensation amount after acquisition of 108 years land and house even after passage of approximately 3 years. तापर से हमको compensation देले नहीं, न दे कि what they did, we are the tenants. सेमाने कहले since the ROR name reflects the original owner, we have paid the compensation, which is at page number 129. Right to information apply करली, supply of information. The undersigned is directed to invite reference to the subject cited above and to say that so far direct section of HNUT is concerned, the information are called and thereby may be treated as nil. No information. Next is Bhubaneswar Municipality Chithi Douchi. Mote. Page 130. In inviting a reference to the subject above, I am to supply here with the point-wise information. The acquisition by way of direct purchase has been made by Bhubaneswar with whom? Not available, no such information about it. Compensation has been paid to recorded tenants. I am the owner. Whom did you pay? And when I have raised an objection that is my property and it has been sent to the HNUD department for inquiry, how can you pay the compensation? And this compensation has been paid after my objection has been raised, which is clearly barred under the law.
You are not aware of whom it has been paid.
It has been paid to 5 and 6. Opposite party number 5 and 6.
On what basis?
I don't know. They said a recorded tenant. That is what they have to answer now. Compensation has been paid to recorded tenants. I am the recorded tenant. Whom did you pay?
Maybe that there may be some other document or some other thing might have.
Let them produce that. Let them produce on what basis they have done. Law is well settled. ROR doesn't create any right nor extinguishes right.
No, that way you cannot say. The ROR doesn't create. That's all. In that case, you have to go to the Court of Civil Court and get it.
I am barred under civil court, my lords.
No, not for this reason. Not for this reason.
Compensation should have been paid to X. It has been paid to Y. So there is a provision that you can approach the authority, and why will entertain this?
Yes. Now question is that when you are recognizing me, you say that you get a record correct.
That can be also recorded after the
Act, my lords. Your lordship may kindly see the act. Section 15, section 11. Again, section 11, there is no notification under section 11. Let them show there is a notification under section 11.
So there is a provision, you can raise your grievance there.
Only after completing section 11.
Which is that provision, Mr.
11, section 11, my lords.
11 is there.
Publication of primary notification powers.
No.
So এইটা को follow করলে যায় কি?
It has been paid to a wrong person or the person who is not entitled to. Then
and I in fact it's my reference that he has been paid to 5 and 6. Let them come and say to whom they have paid. Lordship may kindly see here hearing of objection.
Yes, Mr.
Section 15.
Provision.
Hearing of objection is 15.
Any person interested in any land which has been notified likely to be required for public use may within 60 days from the date of publication. Where is this? There is no my objection has not been taken care of. And section 11 is my lord's publication of preliminary notification. This has also not been done. The procedure has not been followed.
Mr. Das, there is a provision in this 2013 Act. Suppose X is required to be paid and it has been paid to Y. Then the proceeding can. My lord. 40? No, sorry. Sorry. This is under 2013 Act.
Section 64, your lordship may see.
That is reference.
64
reference to authority.
No, that is reference.
He should have referred it to the collector.
You have not raised the grievance before the concerned authority. Why you?
I have raised before the BMC. BMC is the person who will acquire. No, kindly again see the plan. Representation. 72.
It is to be under 64. The person to whom it is payable. So
kindly see my lord's page 89. This is a very important document. I'm sorry I could not place it.
Affection to the measurement of grants and the person paid. So if you give the written application to the collector and say that the amount has been paid to the person who is not entitled to he can refer the matter. That is the provision. A person interested so and so may by written application to the collector require that maybe so and so. Then collector within so and so or the date of decision make a reference to this so and so to the appropriate authority, because these are all disputed thing. It is to be adjudicated by the. That is how such a provision is there.
Page 84. Collector, I have made representation to collector. Page 84.
Page 84.
Yes. And they apply, and the municipality replies to that. I am the present valid legal heir of premises located and so and so. I bring to your notice that I have verbal information from men and assigns. Because I am staying in Calcutta, we are more than 75 years, all are more than 75 years of age.
No.
This has not been.
When you got this information,
yes,
that it has been paid to Mr. X. Thereafter, have you raised this dispute before the collector?
I have been raising, my lords.
Not raising. Once it's come to your notice that it has been paid to Mr. X by the RTI information, thereafter this provision should have been resorted to.
I have again made a representation. To whom have you paid? They have not replied.
No, that is not the way, sir.
That
is not the way.
Lordship, I come to page 89.
You have to make a reference.
Their answer, your lordship, you will get in page 89.
Make a reference to the authority will be made.
Kindly one letter.
Write a written application.
I will. But kindly come to page 89, please. I will just one. What is the answer to that, your lordship? Kindly see. We have received your consent application for handing so and so decimal of land.
Where is that information has been assured? Referring to land counsel for the petitioner, referring to annexure 5, submits that he has received the communication from the Deputy Commissioner Land, Bhubaneswar Municipal Corporation, that the compensation has been paid to the recorded tenant, and it is the case of the petitioner that they are the recorded tenants. And Mr. Mukherjee submits that the compensation has been paid as per the letter to a person who is not entitled to receive the same. Section 64 of the 2013 Act prescribes that in such a case, a written application is to be made to the collector so that the collector can refer the matter for determination of the authority. Since the petitioner has not resorted to this provision after receipt of annexure 15, which is dated 25/6/2024, this petition is disposed of, giving liberty to the petitioner to make a necessary application before the collector, in the event of which he shall make pass necessary order under section 64 of the 2013 Act.
Even though, my lord, suppose, my lord, the collector is not.
Collector has to make the reference to the authority.
If not done by. If the collector has not referred the matter to the authority, then also, my lord, they provided further that where the collector fails to make such reference within the period of so specified, the applicant may apply.
No,
the authority.
He has not yet done. The question is according to the petition is
so lordship, time period.
You have to make the application, Mr.
Unless you make
my
an
application,
application.
that application may not to the collector may be treated as an application, may not.
No, you are
yet to make an application.
Yet to make application. It is on your part. The moment you make an application, he is to be satisfied, and on the basis of this document and that ROR, if he will be convinced, then he can make the reference. That is all, and then appropriate authority will dispose of the matter. Yes. Next.
Item 29.
Lordship. Similar matter, your lordships.
Cover matter.
Yes, sir. Last one, your lordship. Last one, WPC 21,203. The order, similar order, I have annexed under annexation 3.
Copy ଦେଇଦିଅନ୍ତୁ ତା ଦେହରେ ସବୁ ଠିକ ଅଛି ନା କିଛି ଏପଟ ସେପଟ
ନାଇଁ କିଛି ଏପଟ ସେପଟ
ଏଇଟା ସେଟ ଅର୍ଡର ଅଛି
ଏଇଟା ସେଟା ଅଛି
ଦି ପ୍ରକାର କୋଉ ଅର୍ଡରଟା ଚାହୁଁଛନ୍ତି ଦି ପ୍ରକାରର ଅର୍ଡର କୋଉଟା
ଲେଖି ଦେଇଛି ଆଜ୍ଞା
ଏଇ ଯେ ଲେଖି ଦେଇଛନ୍ତି ଏଇ ନମ୍ବର
ଆଜ୍ଞା
ସବୁ ସେଇ ରିପ୍ରେଜେଣ୍ଟେସନ ଡିସ୍ପୋଜ ଅଫ ହବ
ନାଇଁ ଆଉ ଅଛି ଲର୍ଡସିପ ସାର୍ ଡାଇରେକ୍ସନ
will take a decision on this one. Communicate the result thereof to the within 2 weeks of taking the decision. Taking the Yeah.
Last one, the disposal of my application under Section 28A of the Land Action Act, which I have annexed under Annexure 3, similar orders.
ये जो लास्ट वाले annexure 3 ଅଛି ହେଲା ତାର annexure 3 ରେ ଯୋଉ order pass ହେଇଛି last ଟା ସେଇ order pass ହବ ବୁଝିପାରିଲେ ଆଉ ବାକି ଯୋଉଗୁଡାକ ସେ ଲେଖି ଦେଇଛନ୍ତି କୋଉଥିରେ କୋଉ ଟାଇପ ର order ହବ ମାନେ ଯୋଉଟା ଆଗରୁ pass ହେଇଥିଲା
Item 30.
May I please, Your Lordship? Item 30. Your Lordship, here the petitioner has taken petitioner and two others have taken a cash credit loan of rupees 19 lakh from the opposite party number 1. In which the petitioner property was collateral security by the bank. As a collateral security by the bank, then Your Lordship, here the due to non-payment.
You already approached this DRT.
Your Lordship, that case is pending, Your Lordship.
So why have you come here?
Your Lordship, on 6/8/24, Your Lordship, page number 4, you can para it. Your Lordship, on that, on 6/8, point number 8. 6/8/24 at around 11:30 a.m. the opposite party number 1 bank officials and along with the 15 personnel reached the petitioner house situated so and so. At the time the petitioner was not there.
Mr. Counsel, you have already approached the DRT. The matter is sub judice there. So if in the meantime something happens, you want any interim relief, you can very well file an application to that effect, and the authority will pass the necessary order. The tribunal will pass the necessary order. Why have you come to this court by filing a writ petition? So you file an application there. This writ petition has been filed for so-and-so direction. It appears that the petitioner has already approached the debts recovery tribunal in essay number so-and-so, and the matter is sub judice. If the petitioner prays for any interim relief, the same can be paid before the concerned tribunal. Therefore, we are not inclined to entertain this writ petition, which is accordingly dismissed. Yes.
Item 31.
Next, please, Lordship. 5181, the petitioner has granted a lease under OGLS Act after following two procedures. Possession direction was directed to be delivered and possession also delivered. But thereafter, when Bhola family, there are two persons from Bhola family. They were working in one is working in collectorate, the other one is working in Tahsil office. So they got some lands recorded in their names, so they're not entitled to. But anyhow, they started getting disturbance in my possession, and that is the reason why actually in meantime, though possession was delivered to me, but I had not taken a step to record the land because I didn't feel it necessary at that point of time. So I filed a petition. When I filed a petition for recording that my name basing on the lease. It was not done, so I filed writ application for recording the land in my favor. My lord, the writ application was disposed of, and writ application disposed of to consider and pass appropriate order. My lord, dear lordship, that is on 13/4/2009. I'll take a lordship to the relevant, that not be very relevant process. Therefore, my lord, then my lord, the authority without any application of mine simply rejected. No, they cannot be recorded in your name. Thereafter, my lord, on 23/11/2009. The suo revision case was initiated for cancellation of the lease.
Yes.
After 28 years, 81, 28 years. But when I initiation proceeding, I challenged
writ application was filed and the Honorable High Court directed that also to decide on the question of maintainability. Thereafter, my lord, the revisional authority held that revision is maintainable. So challenging that also, I filed writ application for this Honorable Court, and this Honorable Court simply said that since revision is pending, let all the questions be decided before the revisional court. But thereafter, the revisional authority dismissed, cancelled the lease. Lordship may kindly see this stage the impugned order, my lord. If I can choose the other order or judgment of the Honorable Court, but last judgment of the order of the Honorable Court, your Lordship kindly see.
We come to the impugned order.
Yes,
Annexure 30.
impugned order, my lord.
Annexure 30.
Completely impugned order. My lord, impugned order, your Lordship will, that is at starts at page 79. Where the glaring defect, your Lordship kindly see. Yes. Part 12, page 84, my lord.
No, you come to the last page 89.
Page 89, my lord.
89, paragraph number 23.
My lord, page 89.
That is the operative part.
That is the operating portion.
Please.
From the order dated 5/1/81, nothing transpires as to whether Tahsildar Khurda had taken any conscious step to arrive at a conclusion that a cooperative farming society formed by landless agricultural laborers and landless agricultural laborers of village Nayakota have already been settled before the settlement of land in favor of Sri Palta Singh, as because Sri Palta Singh is resident of village Zaman Bhumi and lot of Nayakota. Nothing mentioned as to whether Sri Palta Singh is resident of adjacent village of Nayakota, distance of Nayakota from Zaman Bhumi and as to whether it will be in a position to cultivate the land. From the above, it is also clear that Tahsildar Khurda has not followed the order of priority regarding settlement of land mentioned in section 3.3 of the Samati is accordingly answered. So, my lord, what I am submit, my lord, must kindly see the settlement order, kindly see. Annexed to because why I said that it was following due process, it has been here. Lordship kindly see that. Section 3.
So,
if this will tell if there is such of any such application will be there, then only they will be given preference. There is no such application, and there is a public notice inviting objection. There is no objection received against the settlement by lord on my application. So this will be applicable by the Vijay Court. This will applicable if there is an application by the court. Certainly, the application to cooperative society. Sorry, madam.
What this is the date of lease?
Yes,
as you said 5/1/1981. And when this proceeding was initiated?
2009.
In 87 years.
9. Maximum period is 14 years.
No, 14 years now. It has been.
Now, the amended provision, no limitation is there.
Amended provision when it came?
2013.
Oh, 13. Oh,
2013.
So it is almost similar to one case Mr. Paul was
yes
arguing today.
Fixed it so
that not only you, mainly two things I think you are raising. One is that beyond that period it has been initiated, and it was 14 years at that point of time.
Yes.
So the other thing is that there was notice in this.
As per the provision, there is no application by cooperative farming society. So the observation made by the authority is not applicable here. Actually, not applicable here.
So what was taken up in 1987?
87, my lord, there is the Tahsildar had reported that he had got some land. Yes, that is the reason why lordship,
That is already a report in 87.
87. That party lordship proceeding has initiated thereafter only. Thereafter only.
No. Proceeding, according to you, has been initiated in 2009.
2009. After 87 marriage, the Tahsildar said, Tahsildar said that the petitioner has got some land. The lordship kindly see Annexure 7, page 41.
How can we know that the proceeding was initiated in 2009?
Yes. 2009 because notice was issued.
No. What is the case number?
The case number. UGLS revision 1 of 2009. Page 41 will also get it. Page 41.
That 14 years provision is there in
UGLS Act section
7A3.
7A3. That
পুরোনা বইটা দেখলে জোরে দেখতে
এইটা ମୋ ପାଖରେ ଅଛି ପୁରୁଣା ବইଟା ମିଳିବ
clear.
See, it is a detail. This order is clear. Here, he is mentioning the further cause of action that to cancellation arose when the matter came to my notice on situation. Yeah, the judge in the calibrates
Now please come to page number 45.
Yes,
Mr. Mishra, you are right that this 14 years period has been prescribed in the second proviso to 7A3.
Right.
And that shows that if any order is passed under a mistake of fact or owing to a fraud or misrepresentation or on account of material irregularity of the procedure, then the collector has power by exercising 7A, he can that 7A3,
right?
We can revise it and
right.
But this that would be applicable when it comes to the knowledge of that.
Yes.
So it is not that merely because it was in the year 1981, it can be said that the collector was having the knowledge. Because you see, please come to that 45.
45. Yes.
45, it is mentioned there that the cause of action as to the cancellation arose when the matter came to my notice on 21/8/2009.
No, it will also kindly see the second para. Tahsildar Khurda, 87.
87.
Page 45. Page 45, para starts from Tahsildar. Tahsildar Khurda conducted a detailed probe into the matter. He could ascertain that the lease case record was since long submitted in the court of ADM Puri by the then Tahsildar in the 1987 with recommendation by the then Tahsildar for cancellation of illegal lease granted in favor of Rupalta Singh. The present Tahsildar obtained back the case record from the court of ADM Puri and then he took up the representation of Rupalta Singh for correction of Arwar in his favor. The present Tahsildar verified the report. Then Tahsildar also again revealed that Pata Singh and his family member already possessed 4 acre decimal of land, which is not record I can show from the record, my lord. There is a sanction of this, as such he could not. So from 87, also, so 87 also there. 2001, the 14 years extended in 2001. And the actual aspect also have got to be, because that is also not actual, also that is wrong.
Land senior advocate. The petitioner, Hadu Singh, has prayed for passing the order dated 8/2/2024, passed by the additional District Magistrate, Khurda, opposite party number 3, by Annexure 13, wherein it has been held.
May I, my lord?
Yes.
In the improved order, my lord.
Yes.
And I have glanced on page 82.
Hmm.
May I place, my lord?
Yes.
In pursuance to the above direction of the Honorable Court, the learned advocate for the opposite party appeared before this court and contended that the present division against the lease granted in the year 1981 is not maintainable as it is barred by limitation as per the provision contained in subsection 3 of the section 7A of the Ojulas Act. The second provision of subsection 3 of 7A of the Ojulas Act 1962 specifically provides that no proceeding under the said section shall be initiated after expiry of the 14 years from the date of the order. Next page, madam. 9. That this court, by order dated 23/2/2010, had observed that the petitioner had suppressed the fact of his property and managed to get the lease in favor of for the fourth time. He was also not landless person at the time of the sanction of the lease. The lessee was settled with an impression that he was a landless person by the time due suppression of the fact by the RI as well as the opposite party. Though the lease was sanctioned, the ROR was not corrected. So the sanction lease in favor of the was an effect of fraud or mistake as provided under section 17 of the Limitation Act 1963. Hence, this provision is maintainable in the eye of law, since the reopening of the case was on occasion of the fraud or misrepresentation. The limitation in terms of section 7(3)(a) of the Orissa Act would not apply.
That's which we pointed out to you, the capital number pages.
Or page 45, page 8.
Page 45 was on this. 45 रे आपण जो तहसीलदार खुर्दा जो paragraph conducted a detailed probe in the matter. He could ascertain that the lease case record was since long submitted in the court of ADM Puri by the then Tahsildar in the year 1987 with a recommendation by the then for cancellation of soon granted in favor of so and so. That means since 1987, this thing was not, it is not correct. Has been mentioned that it came to the knowledge for the first time in 2009. That is, he is saying that if it was within your knowledge in 1987, then that period, 14 years is applicable.
But my submission is that as because this is a fraud case and that particular limitation will not be applied.
No, that is how we have already asked here for that.
In the other case, this fraud word is also used in the bar.
Take up tomorrow.
No, we are issuing notice. We are issuing notice. This is a new matter. So
because again, para 10 is also there. Para 10 is also.
Next also para is also very new. 13 and 15, my lord.
कौन लिख लूं? हाँ. That from the order dated 5/1/1981, nothing transpired as to whether the Tahsildar Khurda had taken any conscious step to arrive at a conclusion that the cooperative farming societies formed by landless agricultural laborers and landless agricultural laborers of village Nayakota have already been settled before the settlement of land in favor of the petitioner, as the petitioner is a resident of village Damna Bhui and not of Nayakota. Nothing has been mentioned as to whether the petitioner is a resident of the adjacent village of Nayakota, the distance of Nayakota from Damanbhui, and as to whether he was in a position to cultivate the land. And therefore, it was held that the Tahsildar Khurda has not followed the order of priority regarding settlement of land as mentioned under section 3.3 of the OGLS Act. Mr. Misra drew our attention to Annexure 9, which is the order passed by the additional district magistrate Khurda, dated 23/2/2010. And in the said order, though it has been mentioned that the cause of action as to the cancellation arose when the matter came to the knowledge of the Tahsildar on 21/8/2009, and therefore the period of review under section 7A3 from the said date the revision is maintainable in the eye of law. But in the very same page, it is mentioned that Tahsildar Khurda conducted a detailed probe into the matter, and he could ascertain that Lease case record was since long submitted to the court of ADM Puri by the then Tahsildar in the year 1987 with a recommendation by the then Tahsildar for cancellation of illegal lease granted in favor of the petitioner. It is the contention of Mr. Mishra that the lease was executed on 5/1/1981. Stop. And the second proviso to section 7A3 submits that the collector that no proceeding under this provision, under this subsection, can be initiated after expiry of 14 days, 14 years from the date of order. And according to Mr. Mishra, that even if the order has been passed under a mistake of fact or owing to fraud or misrepresentation or an account of any material irregularity of the procedure, then within a period of 14 years, the collector can exercise the power to correct the same. And the second proviso has been repealed, or that has been in the year 2013. And in the case in hand, since the lease was on 5/1/1981, and since it was in the notice of the authorities in the year 1987 about the illegalities committed, then the proviso, second proviso, is very much applicable in this case, and therefore the OGLS number, what is that?
One of 2009. OGLS revision number.
OGLS revision number 1 of 2009, which was initiated in this case under section 7A3, is beyond the period of 14 years, which is not permissible in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Se aro matter ta ame rakhichu kebe seta 30 tarikh Mr. Dhawanଙ୍କର matter ta
Actually, Mr. Tripathi, you have fixed it to, what is that? 30th. 30th.
This matter on 30th of September 2024.
Well, I paid for entry model because
I issue notice.
Well, thank you for that because I'm in possession of the privilege since 81.
This is all right.
Status quo pilot elections.
We are just issuing notice. In that case, also we issued notice, and you will perhaps you will appear for all the opposite parties. So, Land Council for the state submit that he has instruction to appear. He will appear for all the opposite parties. 5 extra copies of the petition be served on the Land Council for the state by tomorrow.
So it is true that Mr. Mishra is also appearing as a senior advocate from the side of the party. But I have a query. Beyond your representation to the party, you are also to assist the court.
Yes, my lord, that is the first.
Is it true that this is the position of law? Despite this, what is the position of law that is also to be shown?
Yes, my lord.
It is not all.
My lord.
What has been provided in the act is not all.
The knowledge of the party. It is also, my lord. There is it. Though there is a specific provision here,
We'll see.
but law is also that.
We'll
Law is also that. The lord said.
So that's
much obliged.
Supplemental list, item number 1.
ନା କଣ?
ଗଣିଆ କାଗରେ
ଓକିଲ ବାବୁଙ୍କ ପାଖକୁ ଆସିଥିଲ?
ଆଜ୍ଞା।
ସାର୍ଟିଫିକେଟ ଟା କୋଉଠି ପାଇଲ?
ନାଇଁ ଆଜ୍ଞା, ଏଟା ଆମ ଘରେ ତାଙ୍କ ଶାଶୁ ଯିଏ ମୋ ଶଳା ତାଙ୍କ ମା ସେ କୋଉଠୁ ଆଣିକି ମତେ ଦେଲେ, କହିଲେ ନେଇକି ତମ ଶଳାକୁ ଦବ। ମୁଁ ଆଜ୍ଞା ସାର୍ ପାଠ ଆଣିକି ଆସିଥିଲି, ମୁଁ ଏଟା ଜାଣିନି ଏଟା ଏମିତି କି ସେମିତି ବୋଲି ମୁଁ ଜାଣିନି। ମୋ ଶାଶୁ ଘର ଆଣିକି ଆଜ୍ଞା ମତେ ଦେଲେ, ଏଟା ନେଇକି ଦବୁ ଟିକେ ଆଉ ଯୋଉ ତୋ ଶଳାକୁ ଦେଲେ ସେ ଓକିଲକୁ ପାଖକୁ ଦେବି।
ଚୌଦ୍ୱାର ଯାଇଛ ଆଗରୁ? ଚୌଦ୍ୱାର ଜେଲ ଯାଇଛ?
ଆଜ୍ଞା ମୁଁ ଜାଣିନି ଏଟା ବିଷୟରେ।
ହୁଁ?
ଆଜ୍ଞା ବିଷୟରେ ମୁଁ କିଛି ଜାଣିନି ଆଜ୍ଞା, ଏଟା ମୋ ଶାଶୁ।
ତମ ଶଳା
ଆଜ୍ଞା
ଆଜୀବନ କାରାଦଣ୍ଡରେ ଦଣ୍ଡିତ ହୋଇଛନ୍ତି।
ଆଜ୍ଞା
ତମେ ଜାଲ ସାର୍ଟିଫିକେଟ ଆଣିକିନି ଓକିଲ ବାବୁଙ୍କୁ ଦେଇକିନି ତାଙ୍କୁ ମୁକୁଳିବାକୁ ଚେଷ୍ଟା କରୁଥିଲ।
ଆଜ୍ଞା ଦେଖ ମୁଁ ଏ ବିଷୟରେ କିଛି ଜାଣିନି, ତାଙ୍କ ଘର ଲୋକ ଆଣିକି ମତେ ଦେଇଛନ୍ତି, ତାଙ୍କ ଘର ଲୋକ ଆଣିକି ମତେ ଦେଇଛନ୍ତି, ମୁଁ ଏ ବିଷୟରେ କିଛି ଜାଣିନଥିଲି।
ଯାହା କହିବା କଥା ଲେଖିକିନି ତମେ ଲେଖିକିନି ଦିଅ। ବର୍ତ୍ତମାନ ତମେ ଭିତରେ ଥାଅ ତାପରେ ଦେଖିବା।
ନାଇଁ ଆଜ୍ଞା ମରିଯିବି ଆଜ୍ଞା, ପିଲା ଛୁଆ।
ତମ ପାଇଁ କାହିଁ ସେ ଓକିଲ ବାବୁ କାହିଁ ଅସୁବିଧାରେ ପଡିବେ, ତାଙ୍କ ମୋହର କାହିଁ ଅସୁବିଧାରେ ପଡିବେ। ସିଏ ତମ ଉପରେ ବିଶ୍ୱାସ କରିକିନି ଦେଲେ ସେ
ଆଜ୍ଞା ମରିଯିବି ଆଜ୍ଞା, ମୋ ପିଲା ଛୁଆ ମରିଯିବି ଆଜ୍ଞା।
ହଁ
ସେ ମୋ ଶାଶୁଘର ସେମାନେ ଯାହା ଦେଇଛନ୍ତି ଆଜ୍ଞା।
ଯାହା ଲେଖିବା କଥା ସତ୍ୟପାଠ କରିକି ଲେଖିକି ଦିଅ, ଆମେ ଦେଖିବୁ। ବର୍ତ୍ତମାନ ତମେ ଭିତରେ ରୁହ।
ନାଇଁ ଆଜ୍ଞା
Never thought. No. Let him take the file set. Then the affidavit is starting, but he put the file could have taken. And now it will not be okay.
କିଏ ପ୍ରଡ୍ୟୁସ କରିଛନ୍ତି ଜାଣ? Take down IA number 2788 of 2023. This application was filed by the appellant petitioner Giotto alias Sanatan Hissa for reconsideration of the conviction order on the basis of the age factor and setting aside the order of imprisonment for life passed by the London Trial Court, that is London Additional Session Judge Talche in CTS number 26 of 2015 by order dated 4/12/2019. When the matter was taken up on 12/8/2024, after perusing the grounds taken therein and also the documents annexed to the interim application, out your backward look. Say faster.
This is
when the matter was taken up on 15/7/2024, we asked the Land Council for the state to file objection, if any, to the interim application. On 30/7/2024, the matter was listed, and on that day, the Land Council for the state filed the objection. Then the matter was taken off on 12/8/2024. And we peruse the objection filed by the state, wherein we found that the
school transfer certificate which was annexed to the interim application was a forged document. In view of the school admission register and the report of the headmaster of Kathakumpa Primary School. Since the affidavit was shown in the interim application by Dhanardhan Sethi, Advocates Clerk, we issued notice to the said clerk to show cause as to why a proceeding under the Contempt of Courts Act 1971 shall not be initiated against him for swearing the affidavit in this interim application, including forged documents. Thereafter, the matter was taken off on 22/8/2024. And Mr. Dhanardhan Sethi Advocates Clerk appeared in person and filed affidavit wherein he stated that the concerned advocate prepared the affidavit in his name, and on being instructed by him, he shown the affidavit wherein certain documents were enclosed and that he had no knowledge about the genuineness of those documents. And on bona fide faith and good belief, he carried out the instruction of the advocate, and there was no scope on his part to verify and examine the genuineness and authenticity of those documents. On our query, the advocate clerk Dhanardhan Sethi submitted that it was Nityananda Panda advocate who asked him to sign the affidavit. And accordingly, without going through the amendments made in the interim application, he had signed the affidavit. We asked Mr. Nityananda Panda advocate to clarify the position as to from which source he got the document, and he stated that it was the brother-in-law of the appellant who produced the certificate before him, and on good faith he annexed the same to the interim application. Accordingly, we directed Mr. Nityananda Panda advocate to file an affidavit in that respect. specifically indicating the name and details of the person who produced the fake school transfer certificate dated 17/8/2009 before him, which was annexed to the interim application, and the date and the place where it was produced. The matter was then taken up on 27/8/2024, and Mr. Nityananda Panda filed the affidavit wherein he stated that one Gonia Gagarai, son of Siba Gagarai, village Jagannathpur, PS Polieri, Dist Ongur, who is the brother-in-law of the appellant Jotto alias Shanatan Hissa, handed over the transfer certificate to him, and on good faith he accepted the same to be a genuine one, and accordingly the same was annexed to the interim application. After perusing the affidavit filed by the Lennon advocate, we directed the inspector in charge of Polieri police station to produce Gonia Gagarai before this court today. In pursuance of such order, Mr. Sanjeev Jal, ASI of Police, Polieri Police Station on board, has produced Gonia Gagarai before us today. When we made a query to him as to from which source he got the forged transfer certificate and handed over the same to Mr. Nityananda Panda advocate, he submitted that he got it. He said that his mother-in-law handed over the same to him, and accordingly he produced the same before the learned advocate. It is apparent that the prima facie apparent that Gonia Gagarai has produced the post transfer certificate before Mr. Nityananda Panda advocate, and accordingly on the basis of such document, this interim application was prepared, and Mr. Dhanardhan Sethi, advocate's clerk, sworn affidavit in that interim application. The conduct of Gania Gograi prima facie attracts the provisions of Contempt of Courts Act to take action therein in view of the law laid down in the case of Chandra Sasi versus Anil Kumar Verma, reported in 1995, one Supreme Court cases 4-1, Ram Avatar Shukla versus Arvind Shukla, reported in 1995, supplementary to Supreme Court cases 130. That Gania Gagarai file show cause as to why. Accordingly, we initiate a proceeding under SWANS. Why he will not be punished under the provisions of Contempt of Courts Act for producing forged document before this court through his advocate. The affidavit be filed within a week. Matter be listed on 12th of September 2024. It will be taken off at 2 p.m. and till next date, the Gania Gograi is sent to jail custody. He will be produced today before the learned SDGM Sadar Cutter will remand him to judicial custody. Copy of the order be handed over to the copy of the order be handed over to the ASI of police, and another copy be sent by the registered judicial to the concerned court forthwith. ताको नेक्स्ट डेट रखा 12 तारीख रे आपण अबिका ताकू नेकिनी एसडीजीएम कोर्ट रे हाजर करेबे ऑर्डर मु देबी आमे दबुल दस्तखत करिकिनी 12 तारीख जाए से चौद्वार जेल को पठाओ से जा तांकर शो को दबा कथा देबे हला रखी तो डिफेंड कर तो इमीडिएटली प्रेफर करो Convergence is the advocate of Donathan E. Trade Union shall also and present on the next one. Passover from matter of city. That is all. What is it?
Passover item number 17.
17 अच्छा
Item 19.
It will be border for Indian. The last order of the date reference to the last order has been order on J.
Rubis Chubis.
मैंने क्लीन फ्रांच 24 অনুযায়ী আমি allow to petition তার ফাইল করছিলাম এবং the operating portion of the page 40. In this case.
to the creditor in this case, in the appellant's circumstances. Evidence and record. अच्छा पुलिस ऑफिसर्स किए अछंती कोरापुट सर्किल जेल किए अछंती हाँ अपन कौन अछंती हाँ अपन कौन अछंती सब असिस्टेंट जेलर अच्छा आमर जो वकील आसवा कथा कौन है आसना कहीं
फोन करा से कटक काम
ऑडिबल होने ये ठीक कर ये पाखरे रहंतु स्पीकर पाखरे रही कहले कौन है कहीं आसी परलेनी
कटक काम कहले
ओ काम रहले बोली कहले कटक आछंती अच्छा नो सेशन सब्सटीट्यूट मोकदमा साक्ष्य एक को जेरा करने ललिता सबल जब जेरा करने गोटे सुजोग दिया होता तम तरफ तम मान तरफ ललिता सबल को जेरा करने सुजोग दिया जाइथिला एवं सेटा सेई जेरा सरिबा परे वर्तमान आम पाखे सब नथिपत्र पहुंची तेणु आमे वर्तमान शुणाणी आरंभ करू समस्त सुविधा हाँ किसी तम भर क्या कौन किसी कहबार अच्छे कि तम भर किसी कहवाक चाहछ कि आज्ञा समस्त गवर्नमेंट
रेफरेंस जोटा का अछि सेटा का रोल नॉट रेफरेंस जोटा अछि
डेथ रेफरेंस रे आपण अछंती हिमांशु भूषण दास अछंती डेथ रेफरेंस रे मानस चांद अछंती समाधान पई
ତମ ତରଫରୁ ଯୋଉ ଓକିଲ ବି ଦେଇଛ ମାନସ ଚାନ୍ଦ ସେ ଅଛନ୍ତି ଏବଂ ତମ ଯୋଉ ଡେଥ ସେଣ୍ଟେନ୍ସ ହେଇଛି ତାଙ୍କ ତରଫରୁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ତରଫରୁ ହିମାଂଶୁ ଭୂଷଣ ବାବୁ ଅଛନ୍ତି ଏବଂ ଶୁଣାଣି ଆରମ୍ଭ ହବ। ମାନସ ଚାନ୍ଦ ତମ ତରଫରୁ ଶୁଣାଣି ଆରମ୍ଭ କରିବେ ହେଲା।
ଜୁଡିସିଆଲକୁ କହିବେ କାଲି ଯେମିତି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଆଡଭୋକେଟ ନ ରହିବ ହେଲା।
We'll start from
Yes, yes, of course. No question of it. So it should be from the beginning. Because
Afresh, it has to be afresh.
Exactly.
So that's my esteemed brother was.
So let Himanshu, let's start.
Oh, whosoever ଏଇଟା ତାଙ୍କୁ କହିଦିଅନ୍ତୁ ବସିକିନି ଦେଖିବା ପାଇଁ କିଛି।
ହଁ ସମସ୍ତେ ବସି ଯାଆନ୍ତୁ, ସବଜେଲରଙ୍କୁ କହିବୁ ସମସ୍ତେ ବସି ଯାଆନ୍ତୁ, ସେ ବସିକି ସବୁ ଦେଖିବେ। ଶୁଭୁଛି ସବୁ କିଏ ସବଜେଲର ଥିଲେ ସବୁ ଶୁଭୁଛି ତ? ଆଚ୍ଛା
କହିଦେବି କହୁଛି। My lord.
1 minute.
Yes. କେତେ ପେଜ ଖାଲି କହିଦେବି
159 169
Right. Start.
your lordship. This case, my lord, all the accused persons shall be convicted under section 302 read with 34 IPC that death sentence was ordered subject to confirmation by the Honorable High Court with fine, my lord, and offense under section 342 34 of IPC, the 64 of 34 IPC, the 64 of 34 of IPC, 201 of 34 IPC, 5.6 and 34 of IPC read with 4 of which Mounting Act, my lord, OPWH Act, my lord. Read the, my lord, FIR, my lord. As appears from the judgment that the conviction is solely based on the evidence of the period 1 happens to be the direct witness as far as the assault part is concerned, and the other part, death part is concerned, that is completely based on circumstantial evidence. So PW1 happens to be the daughter of the daughter of two deceased and sister of my lord
another deceased, my lord. Your lordship may kindly.
Case of triple murder.
Triple murder, my lord. Triple murder.
That witness is PW1.
Witness is PW1.
And she is the informant in this case.
Informant in this case, and he says that he is the direct witness to the occurrence.
So why don't you place the FIR first?
Yes, my lord. We'll start from the FIR, my lord. My lord. This is my lord, Putasing Police Station, my lord. Sriman Putasing Police Station, Bharapapta Adhikari, Mahasaya, Melta Sabara, that is PW1 and the informant, my lord. Melta Sabara, boys are vice versa. थाना पुटासिंह जिला रायगड़ा लेखि दाखल करने अभियोगर कारण है कि जे गत 9/9/16 तारीख संध्या समय अनित सबर घर को मक्का नहीं अध घंटा पर घर को फेरला पर घरे कहीं नथिले दमंत सबर ठार जाना पाइली मोर बापा माँ और बड़ नानी अश्विनी सबर को गिरिजन सबर का गुहाल
No, Ashwini Sabar is one of the deceased.
Deceased, my lord.
Yeah.
माँ बापा बड़ नानी होची अश्विनी सबर all three are
deceased,
my lord. को गिरिजन सबर का गुहाल रे ग्रामर किछि लोक बांधी रखिछंती सांगे सांगे मु सेठा गली मते मध्य सेमाने अन्य खुंटे बांधी पकाइले सेही जगह रे आम गाँ रो डेंगू सबर दसंत सबर डॉग्स सबर अजंत सबर जामसु सबर एरु सबर लाकिया सबर बुबुनी सबर मालकू सबर पड़ंत सबर उक्त 10 जन
10 जन means this 9.
Another juvenile.
Juvenile is that Jamsu Sabar is the juvenile.
Juvenile.
Okay.
तो 10 जन बंधा होथिबा मोर माँ बापा और नानी को बाड़ी बाड़ी पचार थांती तुम्हें गुणी करी गाँव रा जंजम और बिरंती सबर को मार देछ एबे अजंत घुंगुरी बुबुनार जड़ छाड़ू नहीं तुम स्वामी और स्त्री स्वप्न स्वप्न देखी ज्वर होची ज्वर तुम्हें दायी तेणु सत कथा मानि जाओ नचे तुम परिवार को मारी पोड़ी देबू मो माँ बापा शपथ करी कहउथांती जे आमे किछि गुणगारडी जानि ना एतिक बेले बसंत गोटे सिरिंज आनी सॉरी बसंत एतिक बेले बसंत गोटे सिरिंज आनी सेथिरे मेडिसिन पुराई मोर नानीर तुंडरे और गालरे तथा आखिरे छुंचीरे खेबी पचार थाए अबे सत कथा कह नहले जीवन में मारदेवी एतिक बेले बाकी 9 जन मिसी मोर माँ और बापा को ठेंगा द्वारा निस्तुक माड़ मारता जार मन होଥାଏ से टाही टपरा करी मोर बापा को लाथ गोईठा विधा चापुड़ा मारता परे परे सेमाने मो नानी को मध्य ठेंगारे बाड़ेले ए सब मो बंधा हुई मो निज आखिरे देखिछि तापर से गुहालरू जन जन करी मोर नानी माँ बापा को दरमरा करी नहीं दरबंडा कर नहीं मशान रे पुणी पिटी पिटी मारी पोती देले मते धमक भी कहले जे तत्ते छाड़ी देउछु तू जदि एक कथा काहा आगरे किंबा पुलिस रे कहू तोते मारी तांको जागा को पठेई दबु तो भाई को मार देबु एणु मो भय रे थाना रे रिपोर्ट देली नाही परे काली सुनिବାକୁ पाइली जे उक्त 10 जन आसामी मशाणी को जाई सेही शब गुड़ी बाहर करी पोड़ी देइछंती एबे मध्य मते धमक देउछंती सेमाने जेल बेले गाँव रो बाकी लोक आमको मारदेबे जदि सेमाने न मारंती सेमाने जेल रु फेरला परे आमको मारिदेबे बोली धमक देउछंती एणु जीवन भୟରେ मु कोन करिबी किछि जानी पारि नाही ना कोन जानी पारि नाही तापरे
ଏବେ ସାହସ ବାନ୍ଧି ଆଜି 16/9/16 ରିଖ ସନ୍ଧ୍ୟାରେ
ଲୁଚି ପଳେଇ ଆସି ଗାଁରୁ ଲୁଚି ପଳେଇ ଆସି
ଆଚ୍ଛା ଠିକ ଅଛି ରିପୋର୍ଟ ଦେଲି। ଏଣୁ ବିନୀତ ପ୍ରାର୍ଥନା କରେ କି ଉକ୍ତ 10 ଜଣ ନରହନ୍ତା ଦୋଷୀମାନଙ୍କୁ ଆଇନଗତ ଦଣ୍ଡ ବିଧାନ କରାଇ ବଞ୍ଚିଥିବା ଆମ 4 ଜଣଙ୍କୁ ସୁରକ୍ଷା ପ୍ରଦାନ କଲେ ମୁଁ ଆପଣଙ୍କର ଚିରୋପକୃତ ହେବି। ଚନ୍ଦନ ଲୁନା ଲେଖକ and informant Milta Sabara signed there.
So the formal FIR indicates that the occurrence took place in the evening hours on 9/9/2016.
My lord.
And the FIR was lodged on 16/9/2016, right?
Yes.
Okay.
And what he said from the beginning, my lord, that initially I did not lodge the FIR because they were threatening me. But immediately thereafter he says, କାଲି ଶୁଣିବାକୁ ପାଇଲି page 18 my lord, କାଲି ଶୁଣିବାକୁ ପାଇଲି ଯେ ଉକ୍ତ ଜଜ ଆସାମୀ ମଶାଣୀକୁ ଯାଇ ସେହି ସବୁ ଗୁଡ଼ିକ ବାହାର କରି ପୋଡ଼ି ଦେଇଛନ୍ତି ଏବଂ ମତେ ଧମକ ଦେଇଛନ୍ତି ଯେ ସେମାନେ ଜେଲ ଗଲେ ଗାଁର ବାକି ଲୋକ ମାରିଦେବେ, ଯଦି ସେମାନେ ନ ମାରନ୍ତି ସେମାନଙ୍କୁ ସେମାନେ ଜେଲରୁ ଫେରିବା ପରେ ଆମକୁ ମାରିଦେବେ।
Okay. So this is the FIR. Now you come to the charge.
Charge, my lord, lordship will go to page 21.
Just a minute.
My lord, first charge is the persons are concerned, my lord, that is Dengun Sabar, 9 my lord, all the 9 persons, my lord, because another person has already been tried in another case, my lord, in the juvenile case, my lord. Yes. And this was the Dengun Sabar, Dosunta Sabar, Ajanta Sabar, Padhantu Sabar, Dalsa Sabar, Malju Sabar, Bubuna Sabar, Lakia Sabar, Iru Sabar. I like that on 9/9/2016 evening at about 8 p.m. at village Kitun, you along with others in furtherance of a common intention wrongfully confined the informant Melta Sabar, her father Osina Sabar, mother Ambaya Sabar, and elder sister Osmani Sabar in the cattle shed of Girjan Sabar, and thereby committed an offence punishable under section 342 ready 34 Indian Penal Code and within my cognizance. Second, my lord, that on or about the same day, time, place, you along with others in furtherance of a common intention abducted Melta Sabar, her father Asina Sabar, her mother Ambaya Sabar, and elder sister Asmani Sabar, and tied them in a rope in cattle shed of Girijan Sabar, a co-villager, and again removed Asina Sabar, Ambaya Sabar, and Asmani Sabar from the cattle shed to an unknown place in order that the said 3 persons be put in danger of being murdered, and you threatened Melta Sabar in order that she might be murdered, and thereby you have committed an offence under section 364 ready 34 of Indian Penal Code and within my cognizance. Third, my lord, thirdly, that on the same day, time and place, you along with others in furtherance of a common intention abducted Melta Sabar, her father Asina Sabar, her mother Ambaya Sabar, and elder sister Osmani Sabar with intent to cause them to be secretly and wrongfully confined, and you have therefore committed an offence punishable under section 365 read 34 of Indian Penal Code and within my cognizance. Fourthly, that on the same day, time, and in cremation ground, Mosani, a village, fourthly, my lord, that on the same day, time, and cremation ground, Mosani, a village Kitun, you along with others, in furtherance of a common intention, committed murder by intentionally causing death of Asina Sabar, Ambaya Sabar, and Osmani Sabar, and thereby committed an offence punishable under section 302, 34 of Indian Penal Code, and within my cognizance of the Court of Sessions. Fifthly, that the same day, time, and in the cremation ground, Mosani,
of village Kitun, you along with others in furtherance of a common intention, knowing or having reason to believe that the offense of murder of Asina Savar, Ambaya Savar and Osmani Savar, punishable with death or imprisonment life, has been committed and cremated the dead bodies of Asina Savar, Ambaya Savar and Osmani Savar to disappear evidence with an intention to screen yourself and other offenders from the legal punishment of such murders, and thereby committed an offence punishable under section 201, Redu 34 of Indian Penal Code within my cognizance, Court of Sessions. Sixthly, my lord, that on the same day, time and place of occurrence, you along with others, in furtherance of a common intention, committed criminal intimidation by threatening the informant Melita Savar with injury to her person, reputation and property, with intent to cause alarm to her, and thereby committed an offence punishable under section 506, Redu 34 of the Indian Penal within my cognizance. And seventhly, that on the same day, time and place of occurrence, you along with others committed witch hunting by killing Asina Sabar, Ambaya Sabar and Asmani Sabar, claiming them to be practicing witchcraft, and thereby committed an offence punishable under section 4 of the Orissa Prevention of Witch Hunting Act 2013 and with my cognizance, my lord.
Earlier, when they were found guilty by the additional session judge Gunpur, at that time the charge were framed not under these two sections, 364 and 365, right?
Yes.
And however, the London trial court found them guilty apart from the offences charged also under section 365 of the Indian Penal Code, as it appears from the earlier judgment, right? Yes. And this court in the earlier appeal, that is, what is that appeal?
My lord, that depends 161, my lord. Appeal number, my lord. That's the hospital, 161 plates. 1 by 2000 and JCRL number 46 of 2008.
One, sir,
161.
61.
Sir, total 161 second paragraph. The Honorable Court, while sitting over the matter in death sentence reparation number 1 of 2018 and JCRL 56 of 2018, arising out of the judgment of conviction and order dated 11/4/2018 and 13/4/2020 passed by the learned additional session judge Gunpur.
It is set aside, na?
Sir,
set aside and
demanded back to the
trial court with a direction to add the charge for the offence under section 364 and 365. Achha. So accordingly, this charge was framed. So now, as you said, the star witness on behalf of the prosecution is PW1. It is only he who had seen all the
but as far as assault part is concerned, he has seen. But later she was tied in the cow shed. But the one after other, they were taken to another place.
Before going to place the evidence of PW1, you place the 164 also.
The 164. That is also very important. But this will show, my lord, just what I want to point out. Say, I'll read, my lord, one by one. You also will see the.
No, you will point out. No, you just want to know that because when you argued this matter, your submission, I hope it is that she developed the case from time to time.
Yes, time to time. That
was his submission. So before going to that, once you know, if you point out the contradiction part, we can very well see that. So that is why you just place and then we'll go.
My lord, my lord. So let's see if we'll go to 164 statement. Page, my lord, 95. What is my lord? Page 95. Milka Sabar, my lord. More now, huh? पढ़िया मोर नाम मिलता सबर my lord, 22 years my lord. गत 9/9/16 एक शुक्रवार संध्या 7 घंटा ठारू आरंभ करी रात्र 9 घंटा पर्यंत आम ग्रामर गिरिजन सबनक गुहाघरे मोर बापा मा और बड़ नानी को आम ग्रामर किछि लोक बांधी रखिथिबार कथा मते दमंत सबर जणाइला सेतेबेले मु अमित सबर घर को मक्का देवाकू जाई तांको घरे टीवी देखुथिली एवं सेठारु फेरी घरे खाइबाकू जाउथिली.
You see, just let us be clear.
Yes.
जे जो जिनसटा FIR रे कहितला 161 रे कहितला सब्सटेंशियल डिफरेंस होउची ना टिके एडिशन होउची से याकू माइंड करी कि नहीं आपण जेतेबेले कारण टाइम टू टाइम जेतेबेले चेंज हबो किछि हुए तो एमथि हो बट यदि मेन जिंस ता कंसिस्टेंट रहिला about the assault part. So material contradictions how emiti samanya there is a difference that's what can be have the effect what the court should consider as a material contradiction. Okay, the law is very clear. Upon your first paragraph ta madhyam padhile you find that in the FIR he also stated that jaithila TV dekhiya TV dekhi mokka kon aniyaku tapare se hala
that is there.
We come to the next paragraph.
The next paragraph. खबर पाई मु दमंत सबर सहित घटनास्थल गुहाघर निकट पहुंचा पूर्व किछि बाटरू दमंत सबर इज नॉट एन अक्यूज्ड दमंत सबर दशन सबर कहला दमन सबर दशन सबर इज द वन अक्यूज्ड by but दमन सबर इज नॉट एन अक्यूज्ड by दशन सबर कहला मु मेली ताको डाकी आंची ताको बांधी पकाओ दशन सबर मते बांधी करी मो बाप मा बड़ नानी पूर्वर बंधा होइथिबा गुहाळ घर को नहीं सेठार एक खुंटरे बांधी पकाइले एतर ए जो जिंसटा आड करले
एरा कहूची पुरा
ए जो ने बांधी पकले ठीक अछि बांधिया बाटा किंतु बाटो दमंत सबर दशन सबर कहला मु मेलता डाकी आंची ताको बांधी पकाओ हार माय लॉर्ड थ्री माय लॉर्ड मु सेठार बंधा होइथिबा समय रे आम ग्रामर डेंगू सबर दशंत सबर डल्स सबर बुबना सबर एरु सबर जामसु सबर मालकु सबर पड़ंतु सबर लाकिया सबर अजंत सबर माने 10 जाक मो आखि आगरे मो बापा मा बन्नानी को ठेंगा बाड़ी हाथ लात माध्यम रे माड मारी मारी मोर मा बापा को अचेत पचार था सत को तुम्हें गुणी कर कुह नचेत तुमको मारी मारी जीवन मराई दऊ से समय मोर माँ कहूए आमे किसी गुणी करना मत माड मारी सॉरी पुणी हाँ पुणी माड मारी से माने कहते जदि गुणी करी ना तेबे काहींकी आमे सपन देखिलु काहींकी आम गाँर 3 जन अजंत घुंगुरी बुबुन को जर छाड़ू नहीं सत को नहले जीवन मारदेव
टेक पॉज फॉर अ मोमेंट दैट मींस ए जो पार्ट टा कहूची सब्सटेंशियली मध्य एफआईआर रे अछि बांधी पकेले ता सामना रे एमाने समस्ते से 3 जन को बाड़ेले एवं सेठी मध्य अछि जे ई हिसाब रे मारले आज्ञा सो बाकी किछि आड हेछि इट्स ऑल राइट बट substantially
natural that is important
जो मां पहिला जे हमें करी ना हो that is also there tell that some words are
सतरे तो बापा कहछि तो कहछि मां
तर ता सबमिशन ही सेया थिला तो एथि पई एटा को प्लेस कर देला आगु आ किछि हां यस 4 नंबर पैराग्राफ
चतुर्थ पैराग्राफ एई समय दशंत सबर एक सिरिंज रे चुंची थिबा कपा औषध पुराई एक बाल्टी रे गोलाई करी
ମୋ ନାନୀର ଆଖି, ନାକ, ପାଟି, ଛାତି, ଅଣ୍ଟା ଇତ୍ୟାଦିରେ ଫୋଡିବାକୁ ଲାଗିଥାଏ। ତାପରେ ମୋର ବଡ ନାନୀକୁ ବନ୍ଧା ଯାଇଥିବା ଖୁଣ୍ଟିରୁ ଫିଟାଇ କରି କେଉଁଆଡେ ନେଲେ ଏବଂ ସେମାନେ ଫେରିବା ପରେ ମୁଁ ଜାଣିଲି ଯେ ଆମେ ମଶାଣିକୁ ନେଇଥିଲେ ବୋଲି। ମୋ ନାନୀକୁ ସେମାନେ ନେବା ସମୟରେ ମୁଁ କାନ୍ଦିବାରୁ ଆମ ଗାଁର ବୁବୁନ ଶବର ଏକ କାତି ଦେଖେଇ କହିଲା, ଯଦି କାନ୍ଦିବୁ ତତେ କାତିରେ ଭୁଷିଦେବି ଓ ଆର ହାତରେ ନା କଣ
ଅନ୍ୟ ହାତରେ
ଧରିଥିବା ଇଞ୍ଜେକ୍ସନ ଦେଖାଇ ପୋଡିବାକୁ କହିଲା।
Just stop here.
Sir.
So ଏଇ ଯୋଉ ସିରିଞ୍ଜ ରେ ଫୋଡେଇବାଟା ନାନୀକୁ ଏଇଟା ଅଛି ଏଫଆଇଆର
ନାନୀ କୋଉଠି ଅଛି?
ଅଛି
ହଁ।
ଖାଲି ଏଇ ଯୋଉଟା
କହିଲେ
ଆଡିସନ ହେଇଛି ଯେ ତାକୁ ଦେଖେଇଲା ଗୋଟେ କଣ
ଦେଖେଇକି ଧମକେଇଲେ ସେଟା ନାହିଁ ସବୁ
ସେଇଟା ନେକ୍ସଟ ପାରାଗ୍ରାଫ 5
ସାର୍। ଏହାର କିଛି ସମୟ ପରେ ସେମାନେ ମୋର ମାକୁ ଓ ତାର 10-15 ମିନିଟ ପରେ ମୋର ବାପାକୁ ମଧ୍ୟ ନେଲେ। ସେମାନେ ସମସ୍ତଙ୍କୁ ନେଇ ସାରିବା ପରେ ମୋତେ ବାନ୍ଧିଥିବା ଖୁଣ୍ଟରୁ ଫିଟାଇ ଦେଲେ ଏବଂ ସେଠାରେ ଥିବା ତଦନ୍ତ ଶବର ଓ ଦମନ୍ତ ଶବରକୁ କହିଗଲେ ମୋତେ ଜଗିବା ପାଇଁ। ତଦନ୍ତ ଶବର
ସେ ସେଠି ମଧ୍ୟ ସେ କହୁଛନ୍ତି ଏଫଆଇଆର କହିଥିଲା ଗୁହାଳରୁ ଜଣ ଜଣ କରି ମୋର ନାନୀ ମା ବାପାଙ୍କୁ ନେଇକିନି ମଶାଣି ଆଡକୁ ଗଲେ ହେଲା ସେଠିକି କହିଲେ। ଏଠି ମଧ୍ୟ ସେଇଆ କହିଲା ଯେ ପ୍ରଥମେ ନାନୀ କି ନେଲେ ତାପରେ ବାପା ମା କୁ ନେଇଗଲେ ନେଲା ପରେ ଦେନ୍ ମତେ ଖୋଲିଦେଲେ ସେ କଥା ମଧ୍ୟ ସେଠି ବି କହୁଛି
କହିଛନ୍ତି। ଜଗିବା କଥା ସେଗୁଡା ନାହିଁ। ତଦନ୍ତ ଶବର ଇଜ ଦ ଆକ୍ୟୁଜ୍ଡ ବଟ୍ ଦମନ୍ତ ଶବର ଇଜ ନଟ୍ ଆକ୍ୟୁଜ୍ଡ। କହିଗଲେ ମୋତେ ଜଗିବା ପାଇଁ ଏବଂ ସେମାନେ ଫେରିବା ପର୍ଯ୍ୟନ୍ତ ଏଇ 2 ଜଣ ମୋତେ ଜଗି ବସିଥିଲେ। କିଛି ସମୟ ପରେ ପ୍ରାୟ 20 ମିନିଟ ପରେ ଅଜନ୍ତ ଆସି ମୋ ନାନୀ ପିନ୍ଧିଥିବା ଏକ ସୁନା ଚେନ୍ ଆଣି ମୋତେ ଦେଲା ଓ ତୋ ନାନୀର କହି ପୁଣି ସେଠାରୁ ପଳେଇଲା। ସେଇ ସମୟରେ ମୋତେ ଜଗିଥିବା 2 ଜଣ ଯାକ ଧମକେଇ କହିଲେ, ଏକଥା କାହାକୁ କହିବୁ ନାହିଁ, କାହାକୁ କହିବୁ ତ ସାକ୍ଷୀ ଦେବୁ ତ ତୋର 2 ଭାଇଙ୍କୁ ମରାଇ ଦବୁ ଏବଂ ତମେ ସମସ୍ତଙ୍କୁ ମାରିଦବୁ। ମତେ ମଧ୍ୟ ଧମକ ଦେଇ କହିଲେ, ତୁ ଏକଥା କେଉଁଠି କହିଲେ ତୋ ଭାଇକୁ ମିଛରେ ବାପା ମାଙ୍କୁ ଜ୍ୱର ହୋଇଛି କହି ଡକାଇ ଅଧା ରାସ୍ତାରେ ଜୀବନରୁ ମାରିଦବୁ। ଆଉ କହିଲେ ତୋର ବାପା ମା ଓ ଭଉଣୀକୁ ମାରିବାକୁ 10 ମିନିଟ ଲାଗିଲା ନାହିଁ, ଏଣୁ ତମେ ଭାଇ ଭଉଣୀକୁ ମାରିବା ପାଇଁ ସେକେଣ୍ଡ ବି ଲାଗିବ ନାହିଁ। ଏସବୁ କଥା କହି ସେ 2 ଜଣ ମୋତେ ଜଗିଥିବା 2 ଜଣ ପଡନ୍ତ ପଦନ୍ତ ଅନ୍ୟମାନେ ସେଠାକୁ ଆସିବା ପର୍ଯ୍ୟନ୍ତ ଡରାଉଥାନ୍ତି।
ତାହେଲେ ଏଠି ସେ ସୁନା ଚେନ୍ ଟା ଆଣି ଦେଲା ସେଇଟା ଆଡିସନ ହେଇଛି
ଆଜ୍ଞା।
ଆଉ ଏଇ ଯୋଉ ଧମକ ଚମକ ଟା ଅଛି ମାନେ ଏଇ ଯୋଉ ଡିଟେଲ ଜିନିଷଟା ଏଫଆଇଆର ରେ
ନାହିଁ।
ଓକେ ତାପରେ
ସେ ମୋତେ ଡରାଉଥାନ୍ତି। ତାପରେ ଅନ୍ୟମାନେ ସେଠାରୁ ଫେରି ପ୍ରାୟ 9 ଘଣ୍ଟା କିମ୍ବା 9ଟା ଅଧେ ସମୟରେ ମୋ ପାଖକୁ ଫେରି କହିଲେ, ତୋ ବାପା ମା ଓ ନାନୀକୁ ଆମେ ମଶାନରେ ଟାଙ୍କି ବସିବା ପାଇଁ ଖୋଳା ଯାଇଥିବା ଗାତରେ ମାରି ପକାଇ ଦେଇ ବାଲିରେ ପୋତି ଦେଇ ଆସିଲୁ ଏବଂ ସମସ୍ତେ ମୋତେ ସେମାନଙ୍କ ସହ ଜୋର ଜବରଦସ୍ତ ଗାଧୋଇବାକୁ ବାଧ୍ୟ କଲେ ଏବଂ ମୋତେ ଧମକାଇ କହିଲେ, ଏଇ କଥା ପୋଲିସ ରିପୋର୍ଟ ପାଇବା ପରେ ତୋତେ ମାରି ମାରି ପଚାରିଲେ ମଧ୍ୟ ତୁ କହିବୁ ନାହିଁ। ଏହାପରେ ଆମେ ସମସ୍ତେ ଗାଧୋଇ କରି ଘରକୁ ଫେରିଲୁ। ବୁବୁନ ମୋତେ କହିଲା, ତୁ ତୋର ଘରକୁ ଯାନା, ଆମ ଘରେ ଶୋଇବା। ମୁଁ ତାଙ୍କ ସହ ବୁବୁନ ଘରକୁ ଗଲି ଏବଂ ଅନ୍ୟମାନେ ନିଜ ନିଜ ଘରକୁ ଶୋଇବାକୁ ଗଲେ।
କିଛି ଏକ୍ସାଜରେସନ ହେଇଛି
ସେଗୁଡାକ କିଛି ନାହିଁ।
ଗାଧୁଆ ପାଧୁଆ କଥା
ନାହିଁ, ବୁବୁନ ଡାକିବାଟା ସେଟା ବି ନାହିଁ।
ତାପରେ
ଏହାର ଅଧଘଣ୍ଟା ପରେ ଅଜନ୍ତା ସବର ମୋତେ ଡାକି ଆସି ଆମ ଘରେ ବଢା ହୋଇଥିବା ମୋ ବାପା ମା ବଡ ନାନୀ ଓ ମୋ ପାଇଁ 4 ଥାଳି ଭାତକୁ ବ୍ରିଜରେ ଫୋପାଡ଼ିବା ପାଇଁ ଡାକିଲା। ମୁଁ ସେମାନଙ୍କ ସହ ଯାଇ ସେ ଭାତକୁ ବ୍ରିଜରେ ଫୋପାଡ଼ି ଫେରି ଆସିଲୁ ଏବଂ ଫେରି ଆସିଲୁ। ଅଧା ରାସ୍ତାରେ ଅଜନ୍ତ ବୁବୁନ ମୋତେ କହିଲେ ଆମେ କାଲିକି ମିଟିଂ ବସିବା କହି ଶୋଇବାକୁ ଗଲୁ ନା କଣ? ଗଲୁ ନାହିଁ ସେଗୁଡା ନାହିଁ ଆର ଦିନ ସାର୍ ଏଗୁଡା ନାହିଁ ଆର ଦିନ ସକାଳୁ ପାହାଡ ଉପରେ ମିଟିଂ ବସିବାକୁ କହିବାରୁ ମେମ୍ବର ସମିତି ସଭ୍ୟ ଓ ଅନ୍ୟ ଗାଁ ଲୋକମାନେ ଆସିଲେ ଓ ଆସିକି ସେ 10 ଜଣକୁ କାହିଁକି ମାରିଲ ବୋଲି ପଚାରିବାରୁ ସେମାନେ କହିଲେ ତାଙ୍କ ପାଇଁ ଆମକୁ ଜ୍ୱର ହେଉଥିଲା ଓ ତାଙ୍କୁ ସ୍ୱପ୍ନ ଦେଖି ଆମମାନଙ୍କ ଦେହ ଭଲ ହେଉନଥିଲା, ତେଣୁକରି ତାକୁ ମାରିଦେଲୁ। ସେମାନଙ୍କୁ କହିଲେ ଆମେ ମାରିଛୁ ବୋଲି ତା
ଝିଅ କାହାରିକୁ କହିବ ନାହିଁ,
ଏମାନଙ୍କୁ
ସାକ୍ଷୀ ଦେବ ନାହିଁ।
ତା ଝିଅ କାହାକୁ କହିବୁ ନାହିଁ କି ସାକ୍ଷୀ ଦେବୁ ନାହିଁ। ସେଠାରୁ ସମସ୍ତେ ନିଜ ନିଜ ଘରକୁ ଫେରି ଆସି ଅଧା ରାସ୍ତାରେ ମୋତେ ଧମକେଇବାରୁ ମୁଁ 4-5 ଦିନ ଧରି କାହାରିକୁ ଏକଥା ନ କହି ଲୁଚି କରି ରହିଲି।
So virtually ଏଗୁଡାକ delay in lodging the FIR. That is not there in the FIR. Okay, yes.
ମାତ୍ର 15 ତାରିଖ ଦିନ ସେମାନେ ସେ ସବୁକୁ କାଢି ପେଟ୍ରୋଲ ଢାଳି ପୋଡିବାର ମୋତେ ଆସି କହିଲେ। ଆଉଥରେ କହୁଛି, ମୋତେ 15 ତାରିଖ ଦିନ ସେମାନେ ସେ ସବୁକୁ କାଢି ପେଟ୍ରୋଲ ଢାଳି ପୋଡିବାର ମୋତେ ଆସି କହିଲେ। ଏହା ଜାଣି ମୁଁ ଲୁଚି କରି ଯାଇ ଶୁକ୍ରବାର ଦିନ ପୋଲିସ ବାବୁଙ୍କୁ ସବୁ କଥା କହିଲି। ପୋଲିସ ମାନେ ମୋତେ ଥାନାରେ ରଖି ସେ ଘଟଣା ଜାଗାକୁ ଯାଇ ସାମ୍ବାଦିକ ଡାକିବାରୁ ମୋ ମାମୁଁ ଘର ଲୋକ ଶନିବାର ଦିନ ଏସବୁ କଥା ଜାଣିଲେ। ସେ ଶବର ହାଡ଼ ପାଉଁଶ ଆଦି ଆଣିବା ସହ ଆସାମୀମାନଙ୍କୁ ପୋଲିସ ବାବୁ ଥାନାକୁ ଆଣିଲେ।
These are all after the lodging of the FIR.
after lodging the FIR. ଏଇ ଶନିବାର ଦିନ ଆସାମୀ 10 ଜଣଙ୍କ ମଧ୍ୟରୁ 2 ଜଣଙ୍କୁ ପୋଲିସ ଘଟଣା ଜାଗାକୁ ନେଇକରି ଗଲେ। ଏହା ମୋର ବୟାନ ଅଟେ। ମୁଁ ଗୁହାରି କରୁଛି ମାନେ ଯେମିତି କେବେ ଆଉ ଜେଲ ନ ଫେରନ୍ତୁ, ନହେଲେ ମୋତେ ଓ ମୋର ଭାଇକୁ ମଧ୍ୟ ଜୀବନରୁ ମାରିଦେବେ।
So what you placed so far as this assault part is concerned, as to how he was taken to that cow shed and she was tied and then in her front the 3 members of her family, that is father, mother and sister, were assaulted by all the 10 that has been stated. So that is the main thing. We have to decide, because the main offenses are committed by this kidnapping, abduction or whatever it may be, and murder, this race and also say jo gunigarity eguda sabu a bhitere rahi jauchi sei material le sei aspect re FIR au 164 re सेमिति किछि डिफरेंस है। ऑफ कोर्स आपण कहउछन जे गोटे अक्यूज ना कोन आस्तला जो जी की जानरी चार्जशीट डिफरेंट मैटर। बाकी जोडा को कहउछि 164 है, दैट इज एक्सप्लेनिंग द delay to lodging the FIR.
Yes.
So that is the state of affairs. Now we'll go to the evidence of
FIR भी आउट जिंस कहउछि कोन की जाई सेठी पिटा पिटी करी मारले के मसाने से जदियो बंधा हैतला।
She is not a witness.
Yes, but he कहउछि it is not known from which source he got it, but this also
सुनंदु
yes ma'am
FIR कहउछि जे परे सुनिवाकू पाली उक्त एई गुडा को
नहीं सर सब कहउछि पेज 8 सब 17 आसंदु।
हां से मसानी को से पिटा पिटी मारदेले जान
ସେଇଟା ତ ସେ ନିଜେ ଯାଇନଥିଲା
ଯାଇନଥିଲା ସେ କହୁଛି ସେ କହିବା କଥା କଣ ଜଣ ଜଣ କରି ମୋର ନାନୀ ବାପାଙ୍କୁ ଦରମା କରି ନେଇଗଲେ ମଶାଣୀରେ ପୁଣି ପିଟି ପିଟି କରି ମାରିଲେ ସେ ପିଟି ମାରିବାଟା କୋର୍ଟ କରିବା ସେ ତାର କିଛି ଇଏ କରିନି କୋର୍ଟ ମଧ୍ୟ ଏକ୍ସପିରିଏନ୍ସ କରିନି କିନ୍ତୁ ସେ କହୁଛି ମଶାଣୀରେ ମାରିଦେଲେ ତ ଏଭିଡେନ୍ସ ବି ସେ କହିଛି ମୁଁ କୋଉଠି ଯାଇନି ମୁଁ ସେଇଠି ଶେଷ ପର୍ଯ୍ୟନ୍ତ ସେଇଠି ଥିଲେ ସବସିକ୍ୱେଣ୍ଟଲି ଗଲେ ଏଟା
No, see, at least from this two statement before we go to PW1's evidence, at least it appears that she had not gone to that place where the cremation was made. And she was also not present when they stated to her again
assaulted
and
that part was not there
to the body, so that she was not present. Egudaka sabu se shuniba
all what he transfers
from the either the
accused
persons or that is also.
It is just last in theory till they
you are right. ପର୍ଯ୍ୟନ୍ତ ସେ ଗୁହାଳରୁ ମାନେ 3 ଜଣ ଯାକ ବଞ୍ଚିବା ଅବସ୍ଥାରେ ଥିଲେ ବୋଲି ଯାହା ଜଣା ତାପରେ ଡେଥ୍ ହେଇଛି
lasting theory what my friend saying that correct that on the basis of lasting theory
this is the assault prior to the death and lasting till the early when thereafter they
now you come to the evidence of PW.
PW answer 103. My lord. I am the informant in this case. I know these 9 accused persons standing in the dock and also the child in conflict with law who's been tried separately. Deceased Arsina is my father. Also deceased Ambaya is my mother and other deceased Asmani is my elder sister. Accused Dengun is my father's stepbrother. Accused Dasanta is my first cousin. Being the son of my paternal uncle and rest of the being son of the paternal uncle and rest of the accused persons are my co-villagers of village Kitung. The occurrence took place on 9/9/16.
So ଦି ଜଣ
relation.
ସେମାନେ ହଉଛନ୍ତି relation. Number 1 and 2.
Dasanta.
Dengun and Dasanta. All right.
Stepbrother, father's Dengun is my father's stepbrother and accused Dasanta is my first cousin.
Okay.
Sir. Rest of the co-villagers of village Kitung. The occurrence took place on 9/9/2016. I had gone to Pointo's house to deliver corn, and on my return, after half an hour, I found no one present in our house. And when I looked for my family members, Damanta Sabara of our village informed me that my parents and sister were being tied in the stump inside the cowshed of Girijana. Girijana is the PW2. I rushed to the spot. I cried after finding that they were tied off by these accused persons who were all present over there. They also tied up me in another stump by means of a rope. All of them were assaulting my both parents and sister by means of a lathi, stick, and crowbar.
Crowbar is example.
That is
not there in 161.
Okay, let's see that.
Crowbar, alleging that the witchcrafted co-villagers, as a consequence of which Biranti and Jamjam of our village died. The accused persons continued to assault 3 of them till they lost respective consciousness. At that time, accused Dasanta brought pesticide meant for cotton crops in a bucket and administered the same by means of an injection series on different parts of my sister's body, namely eye, nose, mouth, chest, and breast. As far as Dasanta is concerned, I cried loudly and seeing that accused Bubana, yes. Bubana came to me and threatened me on knife point, saying that if I continue to cry, I will meet the similar consequence. He then pointed injection series and touched it on my neck. Then accused Dasanta, after completing administration of injection, dealt a lathi blows on both of my parents and sister. Accused Dasanta and Iru then unfastened the rope by means of which my sister was tied off, and they took her some other location. Half an hour thereafter, rest of the accused persons took my mother away, and 10 to 15 minutes after, they took away my father. Then they instructed Damanta and accused Poranta to guard me and not to allow me to leave till the return. An accused Ajanta came with a gold neck chain of my sister and gave the same to me, after which he returned back to his previous location. Both Damanta and Pramanta threatened me, asking not to disclose the incident before anyone, otherwise they would kill me and rest of my siblings, me and my rest of my siblings.
This is perhaps in consonance with that 164
Yes,
statement.
Yes,
fully.
Pura.
Damanta and Pramanta are not accused.
Yes.
No, that's not.
Pramanta.
Both Damanta is not an accused, Pramanta is not an accused.
Not an
Right. That's
The rest of my siblings, namely another sister and my two brothers. They also threatened me to bring back my brothers from the school on the pretext of sickness of my parents due to fever, kill them on the way, and will produce the knife with blood stain before me. 10 to 15 minutes thereafter, rest of the accused persons returned back and called me to accompany them to take bath in the spring and return back home, as after killing human being, they are not supposed to go straight to their homes without taking bath. Damanta is not an accused in this case, and Pranatha had not gone to the other spot as he was guarding me. They insisted and forced me to take bath, but I did not agree to take bath, and after they took bath, we returned back to our village. As it was night time, they asked me not to return back home and take shelter in the house of any of them. I then slept in the house of accused Bubuna. Then, sir, about half an hour of my stay in Bubuna's house, accused Poranto, Bubuna, Dengu, Ajanta came to me with cooked food of their house, meant to be taken in dinner, and asked me to accompany them to destroy the same by throwing into the water from the bridge. As they apprehended that non-taking of dinner in the night might go to the notice of their family members, then they decided to convene a meeting on the next day. We then returned back, and I slept in Bubuna's house in that night. In the morning, the accused Iru and Dasanta came and called us to go to the meeting urgently, as they apprehended that villagers may get up early and notice about the occurrence. At that time, my paternal uncle Ghana came to me. I cried by holding him, but as they insisted to join to go to the hilltop where a meeting was organized, we accompanied them.
Ghana, not accused.
Ghana.
On the hilltop, our ward member, Logu Sabar, PW7, my lord, Logu Sabar, husband of Samit member, Darsing Sabar, PW5, and other co-villagers were present, before whom the accused persons confessed that they had killed my parents and sister as due to their witchcraft. 2 of our villagers had already expired, and 3 others, named Ghunguri, Bubuna, and Ajanta, are not getting relief from fever for so many days. Being asked by the villagers, the accused Dasanta admitted that he brought the pesticide from the shop about a week back after he expressed his desire to the shopkeeper to purchase poison in order to kill pigs.
Shopkeeper was not examined.
It is all, and also in correct to the 164, madam.
Now that
Yes, ma'am.
see that is almost
Almost all.
164 statement ଯାହା ଥିଲା ପ୍ରାୟ ତାକୁ ସେଇ ତାକୁ stick କରୁଛି ସେ. Yes.
ଯୋଉ ଗୁଙ୍ଗୁରି ବୁବୁନ ଅଜନ ଯୋଉ କହୁଛନ୍ତି ସେଥିରେ ଦି ଜଣଟା କହୁଛନ୍ତି ବି accused by ଯୋଉ appellants. ବୁବୁନ and ଅଜାନ୍ତ. ଅଜାନ୍ତ ଲେଖା ଅଜାନ୍ତ ଗୋଟା. As per the desert shopkeeper purchased the poison in order to kill pigs. They threatened me in the meeting that I submit report to the police or give evidence in the court. I will not take seconds and for them to kill me, and if they would be kept in jail, other villagers would not spare us because of their threat, considering danger to my life. I stayed in the house of Darsing, that is husband of the Panchayat member, from the day of the meeting on 10/9/2016 till 15/9/2016.
ଏଇଟା ହଉଛି ଯୋଉ ଦର୍ଶିଂ ଆପଣ ହଉଛନ୍ତି PW5.
9 ତାରିଖ ଦିନ ଘଟଣା ହେଲା ସେ ହେଲା ସେ ରାତିରେ ଶୋଇଲା ତାଙ୍କ ଘରେ ଯୋଉ ଗୋଟେ ଆକ୍ୟୁଜ ଘର ଅପଲାଣ୍ଡ ଘରେ ଶୋଇଲା 10 ତାରିଖ ଦିନ
ଭାତ ନେଇ ଫୋପାଡ଼ି
ସେ କାମଟା ସରିଲା ତା ପରଦିନ ଯୋଉ ମିଟିଂ ହେଲା
10 ତାରିଖରୁ
15 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ
ମିଟିଂ ପରଠୁ
ସେ ରହିଲା PW5
ଯାଏଁ ରହିଲା PW5 ର ତାପରେ 16 ତାରିଖ
ଦିନ ଇଏ ଦେଲେ 16 ତାରିଖ ଦେଲେ.
That is the explanation she has given.
Yes.
But she was moving freely in our village. She was moving freely, not under any confinement.
କୋଉଠି କିଏ କହିଲା ଅଛି
confinement
ତାଙ୍କର ରହିଲା
confinement ବାନ୍ଧିକି ଛାଡ଼ିଦେଲେ ତାପରେ freely ବୁଲୁଥିଲା ବୋଲି at least ଏପର୍ଯ୍ୟନ୍ତ ତ ଆସିନି କୋଉଠି ଯଦି ଥିବ cross examination will go to that. Face କରନ୍ତୁ.
On 16/9/2016, I came to know that accused persons brought out the dead bodies of my parents and sister from the ditch where they had buried their bodies, and they set fire those by pouring kerosene on it on the preceding day. On the ditch, one ditch was dug by JCB machine for construction of a water tank where it was learned they had buried the bodies. Hearing about those incidents, I went to the police station and reported the matter at the police station. One Janardhan Lima scribed the report to my dictation, and I had submitted the same with my signature. Exhibit 1 is the same report. The exhibit 1/1 is my signature thereof. I had also given my signature as exhibit 1/2 beneath the endorsement of the scribe that it was scribed to my dictation. As examined by the police, and also my statement was recorded by the magistrate, the JMFC Guntur, and exhibit 2 is my statement recorded by the JMFC Guntur, and exhibit 2, 2/1, 2/2, 2/3, 2/4, 2/5 are my signatures on all 5 pages of exhibit 2.
All right, take pause for a moment.
Sir.
The occurrence took place on 9th, right? Report was made on 16th. So the material part of the evidence, as you placed FIR, then of course subject to what has been elicited in the cross examination, we'll see. This part remains the same, almost that କିଛି addition alteration ଅଛି, ଠିକ ଅଛି, omissions ଅଛି, ଯେ ସି ଗୋଟେ ଜଣଙ୍କ ଘରକୁ ଯାଇଥିଲା ଟିଭି ଦେଖିବାକୁ ନା ଟିଭି ଦେଖୁଥିଲା ନା ମକା
ମକା ଦଳ ଯାଇଥିଲା ଟିଭି ଦେଖୁଥିଲା ତାଙ୍କର
ଦେନ୍ ସିଏ ଆସିଲା ପରେ ଦେଖିଲା ଘରେ କେହି ନାହାନ୍ତି ଏବଂ ଖବର ପାଇଲା ଯେ ତା ବାପା ମା ଆଉ ଭଉଣୀକୁ ନେଇଯାଇଛନ୍ତି ସେ ଯୋଉ ଗୁହାଳ ଘରକୁ ଏବଂ ତାପରେ ସିଏ ଗଲା ଏବଂ ତାକୁ ନେଇକିନି ବାନ୍ଧିଦେଲେ ଗୁହାଳ ଘରେ ବାନ୍ଧିଲା ପରେ ତାରି ସାମ୍ନାରେ ତାର ଏଇ ଯୋଉ 3 ଜଣକୁ ତା ବାପା ମା ଭଉଣୀକୁ ଆସଲ୍ଟ ହେଇଛି ବିଭିନ୍ନ ୱେପନ୍ସ ଆସଲ୍ଟ ହେଇଛି ତା ଭଉଣୀକୁ କଣ ଯୋଉ ସିରିଞ୍ଜ ରେ ଆଖି ଏବଂ
ଅନ୍ୟମାନେ ଆସଲ୍ଟ କରୁଥାନ୍ତି
ତାପରେ ତାଙ୍କୁ ଗୋଟେ ପରେ ଗୋଟେ ନେଇଯାଇଛନ୍ତି ଏବଂ ଆକୁ ଧମକ ଦେଇଛନ୍ତି ଯେ କାହାକୁ ଡିସକ୍ଲୋଜ କରିବେନି ଏଇ ଯୋଉଗୁଡାକ ମେନ୍ ପାର୍ଟ ଜିନିଷ ଗୁଡାକ ଆସଲ୍ଟ ପାର୍ଟ ଏଗୁଡାକ ପ୍ରାୟ ସମାନ କିଛି ଏପଟ ସେପଟ ହେଇଥାଇପାରେ ବଟ୍ ବାକି ସେ ପରେ ଶୁଣିଲା ଯେ ତାକୁ ପୁଣି ବାହାର କରିଛନ୍ତି ପୋଡି ଦେଇଛନ୍ତି that's a different part so you are if we I correctly remember your main argument will go to the cross-examination of course my esteemed brother so your main argument was the delay in lodging the FIR right and that the prosecution has not satisfactorily explained the delay in lodging FIR and to substantiate the same you said that she was not confined by anyone and she was roaming here and there moving here and there she could have very well intimated to anybody even to the PW5 also ଆଉ PW5 ଘରେ ଯୋଉ 5 ଦିନ ନା 9 ଦିନ ଥିଲା ସେଟା PW5 ସପୋର୍ଟ କରୁନି ରାଇଟ୍ ଏଇଆ ହଉଛି ଆପଣଙ୍କର ସବମିଶନ ତେଣୁ
ଏଣ୍ଟାୟାର ଯୋଉ ଅନ୍ୟମାନେ ସବୁ ଏଭିଡେନ୍ସ ତାଙ୍କର ହଉଛି କଣ ତା ଡାଇରିଆ ଆଉ ଇଏରେ ମରିଛନ୍ତି ଡାଇରିଆ ଆଉ
No, you are not the witnesses to the occurrence. Witness to the occurrence is PW1. PW1 ଛଡା ଆଉ କିଏ eyewitness ନାହାନ୍ତି ତେଣୁ ଯଦି let us say that in view of what explanation she has offered before in the court and that is also there in the 164 if the court finds that yes the prosecution has satisfactorily explained the delay in lodging the FIR so that is one part then again comes that whether the PW1's evidence can be said to be a truthful witness because it's a single witness so there's clear cogent trustworthy reliable ଏଗୁଡାକ ସବୁ ଯୋଉ ତେଣୁ ତାକୁ ଆପଣ ସେଦିନ ଆର୍ଗୁମେଣ୍ଟ କରୁଥିଲେ ଯେ ସି ଇଜ ଏ ହାଇଲି ଇଣ୍ଟରେଷ୍ଟେଡ ୱିଟନେସ୍ ସେଇଥିପାଇଁ ସିଏ ଟାଇମ ଟୁ ଟାଇମ ସେ କେସ୍ କୁ ଡେଭଲପ କରି ଚାଲିଛି ବହୁତ ଜିନିଷ ଆଡ କରିଛି ଯୋଉଟା FIR ରେ ନଥିଲା in reply to that if you remember we said that FIR cannot be said to be the encyclopedia ସବୁ ଗୁଡାକ ତା ଦେହରେ ମେନସନ କରିବେ ବୋଲି ତେଣୁ FIR ରେ ଯେତିକି କହିଲା ତାର 3 ଦିନ ପରେ ବୋଧେ 164 ଟା ରେକର୍ଡ ହେଇଛି 16 ତାରିଖରେ ଇଏ ହେଇଛି 19 ତାରିଖରେ 164 ହେଇଛି ଏବଂ 164 ର ଷ୍ଟେଟମେଣ୍ଟ କୁ ପ୍ରାୟ ଷ୍ଟେଟମେଣ୍ଟ ଏଭିଡେନ୍ସ ରେ ପ୍ରାୟ ପାଖାପାଖି ରହିଛି ତେଣୁ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ଡିଲେଇଂ ଲଜିଂ ଏକ୍ସପେକ୍ଟ ସେଟା ଗୋଟେ ଆସ୍ପେକ୍ଟ ଆଉ ଗୋଟେ ଆସ୍ପେକ୍ଟ ହଉଛି ଯେ PW1 ଟାକୁ ଆମେ ବିଲିଭ କରିବା କି ନ ବିଲିଭ କରିବା ଆପଣଙ୍କର ଗ୍ରାଉଣ୍ଡ ଥିଲା ଇଣ୍ଟରେଷ୍ଟେଡ ୱିଟନେସ୍ ହେଲା ଦ୍ୱିତୀୟ ଥିଲା ଯେ ଡେଭଲପମେଣ୍ଟ ଯୋଉ ଟାଇମ ଟୁ ଟାଇମ କିଛି ଇମ୍ପ୍ରୁଭ କରିଛି ତେଣୁ we pointed out to you if we correctly remember that merely because somebody is related witness that cannot be a ground to disprove the evidence and even if somebody has added something or exaggerated something omitted something but thereby his evidence is not shaken or the material part is remains consistent. So in that situation, can it be said that she is an untruthful witness? She is an unreliable witness. এই ଜିନିଷ ଆମେ କହିଥାଉ। ତାପରେ ଏଇ ହଠାତ୍ ସେ ଯୋଉ ଆପଣ ଆଣିଲେ ଯୋଉ ଜିନିଷଟା କଣ ଯେ ସିଏ ଗୋଟେ evidence ଦେଇଛି ସେଠି କଣ juvenile ଇଏରେ, so we will also consider that evidence also, see that how far that evidence and the evidence given in court, can it be said that yes, totally said something different which is not there either in the FIR or it cannot stand together. ମାନେ ଏଇ evidence ଟା court evidence ର ଯୋଉ ଯୋଉଟା ଆପଣ ପଢିଛନ୍ତି ବା ପଢିବାକୁ ଯାଉଛନ୍ତି ସେ evidence ଆଉ ଯୋଉ juvenile ରେ ଯେତେବେଳେ ଯୋଉ evidence ଟା ଚାଲିଛି, ହଁ ଏଇଟା ଗୋଟେ ଏମିତି evidence ହେଇଥିବ ଯେ ଟୋଟାଲି ମନେକର ସେମାନଙ୍କୁ exonerate କରିଥିବ ବା କଣ ହେଇଥିବ, ଏମିତି ହେଲେ ହଁ ଆରେ ଏଇ ଟାଇପ ର ୱିଟନେସ୍ କେମିତି ଆମେ କହିବୁ ଯେ absolutely reliable, because it is solitary witness that statement basis ରେ ଯେତେବେଳେ death sentence trial court ଦେଇଛନ୍ତି, ତେଣୁ ସେଇ ଟାଇପ ର standard maintain କରିବା ଉଚିତ, at least the court should be satisfied that is this witness is wholly reliable, partly reliable, partly unreliable ହେଲେ ତ material corroboration ଦରକାର। ତେଣୁ ଆପଣଙ୍କୁ ସେଇ ରେସିଓ କୁ ଇଏ ଆଖି ଆଗରେ ରଖି now you will go to the cross examination.
Yes.
But the thing is that since the lawyer is not there, we think it will take up this matter tomorrow, and because they might not be knowing that what we are discussing today.
Exactly, they cannot understand.
So we'll make necessary arrangement today itself so that at 2 o'clock come to
ଆଜି ଅନମ୍ୟୁଟ ହେଲେ ସବ ଆସିଷ୍ଟାଣ୍ଟ ଜେନେରାଲ ହଁ ତାଙ୍କୁ ଟିକେ ବୁଝେଇ ଦିଅନ୍ତୁ ଆଜି ଶୁଣାଣି ଆରମ୍ଭ ହେଲା, କିନ୍ତୁ ଆମେ ଯୋଉ ଓକିଲ ବାବୁଙ୍କୁ ତାଙ୍କ ପାଖରେ ରହିବା ପାଇଁ ନିର୍ଦ୍ଦେଶ ଦେଇଥିଲୁ ସେଟା କାର୍ଯ୍ୟକାରୀ ହୋଇପାରିଲା ନାହିଁ, ତେଣୁ ଆମେ ବ୍ୟବସ୍ଥା କରୁଛୁ ତାଙ୍କ ପାଖରେ ଓକିଲ ରହିଲେ ଏଇଠି ଯାହା ପ୍ରୋସିଡିଂ ଆମର ଏଇଠି ଯାହା ହଉଛି ସେ ତାଙ୍କୁ ଦରକାର ପଡ଼ିଲେ ବୁଝେଇ ଦେଇପାରିବେ ବା ତାଙ୍କଠୁ ଶୁଣି ସେ ପାରିବେ। କାଲି 2ଟା ବେଳେ ଆମର ପୁଣି ଆରମ୍ଭ ହବ।
ଏଇଟା ମୋର ନା ଆପଣଙ୍କର? ହଁ, ନାଇଁ ସାର୍।